everybody silence their phones. Thank you, Mr. Campbell. Probably the most guiltiest gang. You call the roll, please.
Yes, sir. Chairman Laidlaw.
Here.
Commissioner Lambert. Commissioner Post. Here. Commissioner Lander. Here. Commissioner Rice.
Here.
Commissioner East.
Here.
And Commissioner Hunter.
Here.
Thank you very much. We've got one other piece of business to take care of that we'll take care of at the end, and that's approving next year's racing dates. And I want to thank everybody for their work yesterday. But I do want to ask you one thing. We're not as slow as we look, so if we can speed this thing up, please do. I'll turn it over. Counselor.
Thank you, Mr. Chair. I'm going to reopen the record in this matter, Bob Baffert versus Arkansas Racing Commission. We already said silent cell phones. It is Tuesday, April 20th, 2021, and I have got straight up 9 o'clock. As we left it yesterday, Council, it is still Mr. Freeland's case. Is there any procedural matters we need to deal with before we get started?
No, but I think there was agreement for me to take a witness first here.
Okay, we're going to take
Somebody
a,
said there was, I don't have any problem.
so take a witness out of order. Is the witness ready on Zoom? And this is
Dr. Cynthia Cole.
Dr. Cole. Dr. Cole, can you hear me?
I can you hear me?
I can. My name's Daniel Faulkner. I'm the hearing officer today. If you would, let's get you sworn in real quick. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Robertson?
Can you state your name, please?
Dr. Cynthia Cole.
Dr. Cole, how are you employed?
I am Associate Professor at the University of Florida and Director of the UF Racing Laboratory.
What is your educational background?
I have a DVM from the University of Florida and a PhD in cardiovascular pharmacology from the university. I completed an internship in equine sports medicine and surgery at Tufts University and a postdoctoral fellowship in cardiovascular pharmacology and molecular pharmacology at the University of Florida, and I am boarded in clinical pharmacology.
Are you the author of any scientific papers or articles?
Yes, I have authored or co-authored approximately 40 published papers.
And have any of those papers or articles been peer-reviewed?
All of those have been peer-reviewed.
And what does that term mean?
Peer review is the accepted process in academia today where scientific studies are written and then submitted to a peer process. So other professors in the industry in academia would review the studies and critique them before the studies are published.
How long have you been the head of Florida's testing lab?
In the current employment for about 2.5 years. Previously, I was director of the laboratory from 2003 to 2006. And prior to that, I was pharmacologist at the UC Davis Maddie Equine Analytical Chemistry Lab for approximately 7 years.
Is the Florida testing lab accredited?
Yes, it is, by the ISO 17025 standard by ANAM, which is the American National Standards Institute, and by the RMTC, which is the Racing Medication and Testing Consortium.
Has the Florida testing laboratory ever lost its accreditation or had its accreditation suspended at any point in time?
No, it has not.
How many equine samples does your lab test annually, approximately?
Currently, we're testing about 10,000 samples a year.
What is the RMTC?
It is a stakeholder organization dedicated to supporting the welfare of the horse and the integrity of the racing industry. It is the Racing Medication and Testing Consortium group.
Are you involved in any way in advising the RMTC?
Yes, I am a member of their Scientific Advisory Council.
What does the Scientific Advisory Council do?
It is made up of the laboratory directors, chemists, pharmacologists from the various programs, as well as several private veterinarians and regulatory veterinarians. And the purpose is to generate policy, make recommendations on the classification of drugs, medications, recommendations for thresholds, which then are passed on to the board of the RMTC and then on to the Racing Commissioners International as well for their adoption.
Mr. Robertson, maybe I should, just for the record, get her to affirm. Dr. Cole, since we're invoking the rule in this matter, is anybody in the room with you or on Zoom with you at this point, witness-wise?
No one is in the room and no one is on the call with me.
Thank you, Dr. Cole. I don't see anybody else in the room either. I just was double checking. Sorry for the interruption.
Yeah, that's fine.
Dr. Cole, what is meant by the term chain of custody?
It is basically a documentation, a paper trail, if you will, on the evidence. And so from the time it is, any piece of evidence, from the time it is collected, how it is processed, handled, examined, and ultimately tested, allows you to be able to track who has had access to that sample, where it has been, what was the state that the sample was in. So basically an evidence trail of handling and access to the evidence.
In your role as the head of the Florida Testing Lab, what's the importance of maintaining a proper chain of custody?
Well, it speaks to the integrity of the sample. So ultimately, we must be able to prove that the sample came from the animal that it says it was collected from, that nobody could have had access to that sample other than those who have had supposed to have access to the sample. There was no ability to tamper with the sample, no mishandling of the sample, or misidentification, mix-up in the samples. And all of that goes to the veracity and the integrity of the results, so that when we indicate there is a negative analytical finding, a positive finding, that is indeed the fact that represents what was in the horse at the time of the sample was collected.
Does the term broken chain of custody have any meaning to you?
It generally indicates there's a problem with the way the sample was handled, or something about the way that the sample was collected or handled. It's probably one of the most difficult areas that we deal with in terms of maintaining appropriate chain of custodies, particularly outside of the laboratory, or when we're transporting samples, because it's sort of the weakest link, if you will, and it really unfortunately puts the final results in jeopardy, or at least in doubt.
What is a litigation packet?
The litigation packet or data packet is the evidence that we put together when we have an adverse analytical finding. So we the laboratories, combine all of the chain of custody evidence, the screening results, data from the screening, data from the confirmation, into a packet that can be reviewed in one sort of setting. All of that evidence there together is referred to as the litigation packet.
Have you reviewed the litigation packets in this case for both Charlatan and Gamini?
I have.
Did you notice any chain of custody issues in those litigation packets?
Well, for reasons that I don't really understand, at least simply based on the packets themselves, it's unclear why the samples were shipped from Oaklawn to Truesdale. The samples and coolers were opened, the samples were logged in, and then apparently they were put back into coolers and shipped to industrial, where they were ultimately tested. But there isn't a good chain of custody documentation between when the samples were received and logged in at Truesdale and then getting to industrial.
In your experience as the head of the Florida Testing Lab, if the chain of custody is broken on the primary sample, can you just use the split sample instead?
Yeah, I'm going to object. This is
Absolutely.
Just a minute, ma'am. I'm making an objection in the record. So when I make an objection, you have to cease testifying. My objection is he's asking for a legal conclusion which she's not qualified to make,
There is no law to that effect. That is absolutely incorrect legally, and there's no, unless they can cite some law, which they can't, and she cannot testify to a legal question.
It's not a legal question.
I'm gonna note it for the record, and you can handle that on cross, Mr. Freeland. Thank you.
In your experience as the head of the Florida testing lab, if chain of custody is broken on the primary sample, can you just use a split sample instead?
That is not my experience, no.
What is the importance of properly identifying the sex of a horse?
It's very important because at Florida, as well as Arkansas, is my understanding, we have different rules and different thresholds based on the sex of the horse. So a gelding would not be permitted to have more than 25 picograms of testosterone present in a blood sample, for example, whereas a intact male or colt, we would not test for testosterone because we would expect there to be nanograms in the blood sample. So and the rules are different again for fillies and mares. So we regulate currently anabolic steroids very closely, so knowing and correctly identifying the sex of the horse is very important.
In review of the litigation packet for Charlatan, did you notice any issues related to the identification of the sex of Charlatan?
Yes, it appears that at Oaklawn, the horse was identified as an intact stallion, intact male, and was logged in at Truesdale as a gelding.
And what is the result of that when it comes to the testing of that sample? How does that impact the testing of the sample?
Well, there's two things that this sample should have been, if it was from a gelding, the sample in all likelihood should have had a significant overage of the level of testosterone. So if this was truly a gelding, then sample and it did not have an overage of testosterone, then it likely did not come from Charlatan. The other possibility is for some reason there was a problem with the testing process where the overage of testosterone in a sample labeled as a gelding was not identified.
What is lidocaine?
Lidocaine is a local anesthetic. So these are a class of drugs that produce a numbing sensation, is probably the most easy layman term to identify it. It acts by blocking sodium channels on conductive tissue. So when placed over a nerve, it prevents the conduction of a pain process. So for example, if I had a toothache and I put a bit of lidocaine cream or ointment on my finger and put it on my tooth, it would be absorbed onto those nerves and prevent the nerves from communicating the fact that my tooth was hurting to my brain.
Have you been involved in any research studies which have examined the pharmacological effect of medications on horses?
Yes, the vast majority of my publications deal with horses and drug and medication issues.
And are you familiar with scientific studies related to lidocaine and its pharmacology in horses?
I am. In preparation for this case, I've reviewed a significant amount of the literature looking at lidocaine, other related anesthetics, local anesthetics, and their effects on horses.
What is your understanding of the levels of lidocaine supposedly found in both Charlatan and Gamine?
That Charlatan was found, the sample supposedly collected from Charlatan was found to contain 46 picograms of 3-hydroxylidocaine, and Gamine was said to contain 185 picograms of 3-hydroxylidocaine.
What is 3-hydroxylidocaine?
It is what we call a metabolite of lidocaine. So lidocaine is a very fat-loving or lipophilic compound. That's why it can penetrate into nerves. In order for the body to eliminate these types of drugs, they metabolize them or change their structure. And the way that the body, particularly the horse, metabolizes lidocaine is to put a hydroxy molecule on that, which makes it easier for the body to eliminate it by the kidney and into the urine. So 3-hydroxy is the most abundant metabolite of lidocaine in the horse. It is also an inactive metabolite, so in and of itself, it has no local anesthetic activity.
So what would have been the pharmacological effect on Charlotte on the 46 picograms of 3-hydroxylidocaine?
At that concentration, at any concentration, the presence of 3-hydroxylidocaine is not pharmacologically significant.
And the same answer with regard to gamine, with 185 picograms of 3-hydroxylidocaine, what would have been the pharmacological effect there?
Yeah, the pharmacological effect, there would not have been a pharmacological effect associated with that level of 3-hydroxylidocaine in the horse.
Dr. Cole, you were present at the Stewart's hearing, correct?
That's correct.
And you heard the testimony of Jimmy Barnes at the Stewart's hearing?
Correct.
And you heard his testimony of Salon Paz patches and then discovering that that particular brand had lidocaine in it?
Yes, I did hear that testimony.
Let me ask you this, from a scientific standpoint, was Mr. Barnes's testimony possible or plausible for what you found in the litigation package?
Yes. Yes, I think it's absolutely plausible, and it's consistent with some of the published literature as well.
Are there other possible explanations here if there were other horses during the meet or in the race that also had levels of lidocaine?
Right, it also could have been, so here we're talking about, with Jimmy Barnes, it would be a larger exposure further out from the race. My understanding would be probably Friday, and the race was Saturday. It's also likely that it could have been a much smaller exposure, much closer, even after the race at these levels. I think one of the things that most people do not understand is how little it takes of one of these types of topical applications. In the case of Mr. Barnes, it was a patch, but lidocaine is present in a plethora of over-the-counter medications and topicals, creams, and I would guess many people don't even know that that's what's in them as active ingredients. And if you get that on your hands and you touch the horse, maybe you lift his upper lip to look at the tattoo, you place the bit in the mouth, you do any kind of manipulation of feet or brain, all of that, is, amazingly as it sounds, that small amount of exposure could result in these types of concentrations in the horse, based on my experience studying this and other drugs, as well as reviewing the analytical data and the published data.
What is a picogram?
A picogram is a very, very small unit of mass. It is, the way that I like to compare it to is, if you think about one cell in your body that has a nucleus, and you understand, or think about DNA, which is the blueprint, genetic blueprint of life. One cell, the DNA in that cell weighs approximately 1 picogram, so a very, very small amount.
I've heard it referred to as a trillionth of a gram, is that correct?
Correct, that would be a trillionth of a gram.
And do you have any understanding of how the RMTC came to recommend a 20 picogram threshold for lidocaine?
I do. My understanding was it was primarily based on or is entirely based on a study of 6 horses that were administered 200 milligrams of lidocaine subcutaneously. Those horses were actually dosed at the University of Florida, and those samples were then analyzed at Iowa State. The initial analysis, the limit of quantitation in the protocol was 100 picograms. After reviewing the data, I read of discussions within the RMTC Scientific Advisory Council that they didn't feel like that was sensitive enough, and they asked Iowa to improve the testing sensitivity. Iowa came back and had a limit of quantitation of 20 picograms, and ultimately that became the threshold because that was what Iowa and the other majority laboratories felt could be their limit of quantitation.
You indicated that there are 6 horses in the Iowa State study. Is that unusual for a study?
I would say that is, yeah, that is the bare minimum that you could get published in general. In a peer-reviewed scientific article would be a minimum of 6. It's the bare minimum you would want to look at.
Is 20 more typical?
Yeah, I think the standard that the Scientific Advisory Council and the RMTC has come to accept is a minimum of 20 horses. That's important because it's a better reflection of the variability that we expect to see in the average population. 6 is just too few to really accurately mirror what we would expect to see in a typical population of horses.
Has the Iowa State study ever been peer-reviewed and published?
Not to my knowledge.
What's your professional opinion of the Iowa State study?
I think that it was a good start. It was an appropriate pilot study, but given what we know about lidocaine, particularly lidocaine, given that it is so common in over-the-counter preparations, and the aspects of these type of environmental contamination is so possible, I think we really should have done additional studies with additional horses, perhaps different dosages, trying to understand the pharmacology, the pharmacodynamics behind the drug, or the lack thereof. So it was a good start, but we really should not have set a final threshold simply based on 6 horses and 1 dose.
Are you familiar with the sensitivity of modern day post-race testing?
Yes, I am.
And how does that compare to the past?
Oh, and we have dramatically improved our ability to detect drugs and medications from hours to days to weeks. When I first started in this industry, we were still doing thin layer chromatography, which probably had a sensitivity in the nanogram per ml range for many analytes. And now we're down into the picograms, so 1,000-fold more sensitive than we were testing for it 25 years ago.
Is the current 20 picogram threshold for lidocaine scientifically based on pharmacology in the horse?
Not in my opinion.
That's all the questions I have. Thank you.
Mr. Allen, did you have anything additional?
No, sir.
Mr. Freeland, your witness?
Dr. Cole, yeah, you testified that you heard the steward's hearing where Mr. Barnes was testifying, is that correct?
I did, yes.
And you realize that Mr. Barnes was an employee and an assistant trainer for Mr. Baffert, is that correct?
Yes, that is my understanding.
Now, you said it is plausible that Mr. Barnes' use of lidocaine in the patches could have resulted in positive tests for the horses that Mr. Barnes was around, is that correct?
That is correct.
Are you familiar with the absolute and sure rule that Arkansas has and most racing jurisdictions have?
I am.
Do you understand Mr. Baffert as the trainer is the absolute and sure of what goes on in his barn, and he is responsible for having Mr. Barnes in the barn with the lidocaine patches?
I do understand that, yes.
Now, you said the lidocaine in the horses in Gamine and Charlatan had been metabolized, is that correct?
That's correct.
Now, metabolized means that the drug had gone through the horse's system, is that correct?
That is correct.
So to be metabolized, it had to either be injected in the horse or into the mouth of the horse or a cut on the horse or something like that. Would you agree?
In some manner, the horse was exposed to some level of lidocaine, correct?
If the horse was exposed to some level of lidocaine, the trainer is the absolute insurer of that exposure. Would you agree?
I think there are mitigating circumstances that are beyond the trainer's control, such as in the test barn or other areas that also could result in exposure, in my experience.
Yeah, when a lab is testing for lidocaine, does the sex of the horse make any difference when you're testing for lidocaine and not hormones?
Testing for hormones is part of the process of the testing. We don't just test for lidocaine. I don't do a test for lidocaine. I do a screen for all permitted and non-permitted substances, and my understanding is that was how the samples were to be tested at industrial/Truesdale. So it doesn't interfere or alter the test for lidocaine, but we don't do a test just for lidocaine in a screening process.
I understand you say you don't do just a test for lidocaine, but lidocaine shows up in the urine or blood of a horse regardless of the horse's sex. Would you agree?
That's true.
I don't have any other questions.
Mr. Robertson?
Dr. Cole, if sample 106032 actually came from Charlatan, would you have expected it to test positive for testosterone?
Yes, I would.
Thank you.
Mr. Freeland, anything further?
No.
Commission questions for Dr. Cole?
Thank you, Doctor. Is there any movement in y'all's profession about clearing up this on the levels of drugs that are in there? We get, as commissions, we get rules, okay? And it comes from the scientific community. And then you expect us to come back and become scientists ourselves and overrule the scientists. Is there movement afoot right now to change lidocaine movement that you're aware of?
There has been a lot of discussion recently at the level of the RCI, Drug Testing Standards and Practices, as well as the Scientific Advisory Board, around all of the thresholds and around the scientific data that was used by the Scientific Advisory Council, which I'm a member of, and whether or not we used enough horses of racing age, fit horses, etc. I think we're in the process of re-examining some, if not all, of the thresholds and how they were established and whether we need to go back and do additional studies. Other compounds have been mentioned. My personal opinion is lidocaine is actually one of the weakest that we have set a threshold for.
I appreciate that, and I don't mean, this is not adversarial, but I'm trying to say, should we ignore the rules out there or not?
I think that this is one is problematic because horses don't live in bubbles and they live within the real world. And we do recognize, for example, let's take a very similar drug, mepivacaine, which acts in many ways very similar to lidocaine as a drug, but it is not, to my knowledge, available as over-counter preparation. And so when we see a lidocaine or a mepivacaine positive, which we do see, inevitably when we go and talk to the trainer and the veterinarian, we find out that sometimes the horse had a laceration sutured a week or 2 weeks previously. Many veterinarians don't use lidocaine because mepivacaine is, in most of us think, a better local anesthetic, at least in the horse. But here we have a drug like lidocaine that is present in many over-the-counter preparations. And we are testing at a very, very sensitive level. And so I think that it goes to mitigating circumstances that, particularly if you've had another lidocaine in a horse that same day. I can't remember the last time I called the lidocaine here in Florida. We've had a suspicious that didn't confirm, but it's very, very uncommon. Now, different tracks and different veterinarians use different drugs, so it is quite possible that veterinarians in Arkansas are using a lot more lidocaine is that these guidelines, thresholds are guidelines, and that when mitigating circumstances are present, if it seems rational and if it seems realistic, and you add on other positives and exposures that may have happened, that's why we have boards that can look at evidence and reasonable doubt and make rulings not just based on a black and white number.
Thank you. I would just like to see it picked up more on where it's not left, come out with rules, let's stay with the rules, or let's get rid of the rules. If there's a stop sign, I'm supposed to stop.
I can appreciate your situation.
had
I can appreciate your
Mr.
situation.
Mr. Landers.
Commissioner Post, Dr. Cole, did you get a chance to see the entire screening test on Charlatan that was performed by Industrial?
I only received the litigation packet. So there is undoubtedly additional screening data that was not included in this packet.
So you didn't get to see the entire screening. What I wanted to ask you about was, did the screening come back positive for an intact male? That was the testimony yesterday by Petra Hartman from Industrial, that it came back positive for an intact male. So did you get a chance to see that and confirm that, or do you have an opinion on that?
I looked through the data packet, and I don't see any indication where it says that finding. It traditionally, that would not have been something that I would have included in the packet per se at Florida. However, if at the time that I was putting a packet together, I recognized that there was a problem with how the horse was classified, I would have included something to say this horse had testosterone level consistent with an intact male, and it was incorrectly entered as a gelding, or some understanding of explanation if that's what had happened. They may not have identified that until after the litigation packet was put together, and that's why there's no indication, or at least I didn't see any indication that this horse screened as an intact male. Then the question would be, why did the laboratory not, how did the laboratory identify that this was supposed to be an intact male, if indeed its records indicated that it was a gelding? Did that make sense?
Yes, thank you very much.
Mr. Landers?
Dr. Cole, Steve Landers, what if you injected a horse with lidocaine prior to a race? What would the pico level, or what would he come up if it just got a straight injection 2 days before the race or a day before the race? What would that come up to? Would it come up to 2? Would it come up to 2.5?
Great. So I based a lot of my analysis on a publication that was done by Larry Soma out of the University of Pennsylvania some years ago. For example, when they injected 200 milligrams, so the same dose, subcutaneously, within the first 5 minutes, the concentration of both lidocaine and the parent, or 3-hydroxylidocaine and the parent lidocaine, are above a nanogram, peaking at around 10 nanograms per ml. The concentrations reach into the levels that we're talking about at this horse, into the small picogram, approximately 16 hours, 14 to 16 hours after that administration. If the horse is exposed to a lot larger concentration, 400 milligrams, topically, so this may be closer to how we think Mr. Barnes could have exposed the horse. These concentrations aren't reached, concentrations seen in Charlatan and Gamine aren't seen until 24 hours after the exposure. So these concentrations produced in these horses could certainly have been from 24-hour exposure, 12 to 24 hours or longer before the sample was collected. There also could have been a very small exposure very close to the time of collection. But an injection of a therapeutic dose very close to the race would have produced concentrations in the nanogram per ml range. And I think that's again, a little bit of what we're missing is what would smaller doses produce, how long the duration. The duration of effect of lidocaine is minutes to several hours at the most, and I think that's one of the difficulties we have is lidocaine is not a long-acting local anesthetic, but it can be detected in urine and plasma samples for a day to 2 days or longer after administration, or after even a small exposure.
Okay, thank you.
Commission?
One more question, and I don't mean this derogatory at all, I'm just trying to make sure all labs are kind of created equal. Do y'all ever make any clerical errors?
Yes, no lab is perfect, absolutely. Absolutely, we all make mistakes on occasion, without a doubt.
Thank you.
Commission, any further questions? That was commission, so I'll let you have the witness, Mr. Robertson.
Dr. Cole, just a few things I want to be clear on. If this sample 106032 actually came from Charlatan, you're aware that Industrial tested it believing it was a Gildan, right?
Object, he's saying what
Correct.
Industrial believed, no human can testify or say what Industrial believed. They should have been asked when they were witness. That is an improper question. You cannot say what somebody else believes.
Mr. Freeland, this has gone on for 2 days now. I
It's
appreciate
gone
you
on
letting
because
me
you've
make-
asked an improper question,
Well, I
think
and that is
I'm
misleading
not
to
asking
this board.
improper questions.
I think he can testify to what her state of mind was about the test.
You can ask what her state of mind was, but to ask what Industrial state of mind was is a height of absurdity.
Fair enough, I'll note it for the record.
The documentation that you've reviewed, that Industrial had, what does it indicate that Charlatan is from a sex standpoint?
The documentations that Industrial received from Truesdale indicated that Charlatan was a Gildan.
And given that, would you have expected there to be documentation indicating that if this sample actually came from Charlatan, that it was high in testosterone?
Yes, or some type of notification that they identified a high testosterone and went back to verify the sex of the horse,
Now,
which is lacking. No identification no indication that they went back to clarify the sex of the horse.
to be clear, we've talked about lidocaine and 3-hydroxylidocaine. Lidocaine is the parent compound, right?
Correct,
And that's the compound that's active, correct?
correct,
And 3-hydroxylidocaine is the inactive metabolite, correct?
that is correct.
And what we found, or what the litigation packet, 3-hydroxylidocaine, the inactive metabolite, correct?
Correct.
If your lab makes a clerical error, do you issue a corrective action report?
I did.
Have you seen any corrective action reports in these litigation packets?
I have not.
Nothing further.
Mr. Allen?
No, sir.
Mr. Friedland?
Yes. Dr. Cole, now you work for the University of Florida testing lab, is that correct?
That is correct.
And does your lab test for the state of Florida?
That's correct.
Does
The
the
Division of
state,
Financial
does
Awakening
the state
is
of,
our largest client.
excuse me, does the state of Florida have a threshold level for lidocaine?
Yes, they do. Yes, they do.
And is it the RCI rule of 20 picograms?
Yes, it is.
All right, so the state of Florida has the same rule that Arkansas has on the threshold for lidocaine. Do you agree?
Yes, they do.
Do, work for other states besides Florida?
No, we do not at this.
The doctor, you are aware that the 20 picogram LEI model rules, is that correct?
That is correct.
No other questions?
Mr. Roberts, anything further? Commission, questions?
Alex Lee, one other question, I'm trying to get it straight in my mind. Did Industrial Labs come out yesterday and say that she admitted that they made a mistake and it was a code and they hadn't filed yet, or? I know,
Well, we're kind of asking, Chairman, you're kind of asking the attorneys for testimony at this point. That,
okay, let me ask the rest of the commission. All right, Michael Post is gonna answer that.
I'm just trying to keep it.
It was my understanding from Petra Hartman that the test actually was confirmed an intact male, was her language, but that the assistant failed to note the difference between the fact that the documentation from Truesdale indicated a gelding, but it did in fact come that positive for an intact male, and I took that to mean it was very high in testosterone. That's what I understood.
And his medical background is what? Yours?
Dentistry.
Dentistry. Thank you.
I have a question, Commissioner Hunter. Do we have in either of these packets a copy of that test, of the testosterone in particular? So we have a copy of that we could review? Not that I'm an expert.
I only have what I've been provided, which were the litigation packets.
You had the litigation package, it's my understanding that was not included in the litigation.
For those of us that aren't in this field, it's hard to get an understanding of what that looks like, and if there was a high testosterone level, higher than a gelding would have expected, is that flagged on a test, or is it something that has to be interpreted by by who is interpreting the test, and does that have to be pulled out of data, or is it set forth at the front, this horse test very high in testosterone and that's abnormal? Could someone answer that question?
I think
I hate to be a stickler, but
Okay.
we've got Dr. Cole up here right this second.
Well, she can answer that
Can
question.
she answer that
Could she-
question?
yeah,
You
that's-
said she
Okay,
could.
Sure.
fair enough.
That'd be
I just
great.
want to make sure we don't get off in the ditch a little bit on procedure.
Did you understand my question, Doctor?
Right. Yes. So, again, based on the literature, intact stallions generally have concentrations of testosterone well above 100 picograms or higher, and geldings have very little testosterone, obviously, because they're geldings. So in our screening process, we generally will look for anabolic steroids, and it's a very quick process. If it's a stallion, actually, at least in Florida, and I suspect they do similar, is we identify geldings and fillies and mares, and if we see high testosterone in any other animal, we ignore it because screening result indicating reductive glycane followed by a confirmation process, we would have a packet that says screening result indicated a high level of testosterone, and now we're going to take it to confirmation and confirm that there was an overage of testosterone in this gelding. What it appears they were said was the sample was identified as having high level of testosterone, but nobody flagged the fact that it was supposed to have come from a gelding. And so there likely is a corrective action working its way through the process of industrial now. How did we fail to flag a gelding sample that was labeled as a gelding and had a high testosterone in a screening test? Does that make sense? Does that answer your question?
Yes, thank you.
Commissioners, any further?
Let me make sure I understand this. you do the testing for Florida, the rule in Florida is 20 nanograms. You don't believe in 20 nanograms, but you still have to call it as positive. Is that correct? Picograms, excuse me.
In this situation, I would call the positive, and if I had the indication that there were 3 horses in a single day at a same track that tested positive for lidocaine, I would discuss with the division an opening investigation to see if there was some aspect of how these horses could have been contaminated. And it would go to mitigating circumstances if we found evidence that there was some type of contamination that had occurred that was responsible for these positives.
Thank you.
Mr. Robertson, do you want to, Mr. Freeland?
No questions.
All right, if there's nothing further, Mr. Allen, anything?
No, sir.
If there's nothing further, Dr. Cole, thank you very much. Have a
Thank you,
great
Dr.
day.
Cole.
Thank you.
Thank you.
Thank you very much. I appreciate your time. Thank you.
So we took Dr. Cole out of order. Mr. Freeland, back to your case.
John Campbell.
Mr. Campbell, did we swear you yesterday? We didn't.
No, I don't know if I did or not.
Let's do it just to be safe when you get over there.
You better check me every day.
If you would just raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
So help me God.
Thank you, Mr. Campbell. Mr. Freeland.
Campbell, would you state your name?
John C. Campbell,
And what is your position with the Arkansas Racing Commission?
director of it. I work for the commission.
How long have you been the director of the Arkansas Racing Commission?
4 or so, I don't know, I hadn't kept up with the time. It's gone by pretty fast, but at least 4 years, I think.
Yeah, were you contacted in March of 2020 by Truesdale Labs concerning their accreditation?
I was.
Was that in the form of a Skype telephone conference?
Yes, sir.
Now, if I understand, a Skype telephone conference is on the telephone, but if there's a video of the person you're talking to, is that correct?
Yes, sir.
Who was on that telephone conference?
Anthony Fontana and another lady, and I forgot her name, Shelley or Sherry.
Was anybody else on the conference for the Racing Commission?
I think maybe Dr. LeCank was.
And for the record, Dr. LeCank is the veterinarian for the Arkansas Racing Commission, is that correct?
Yes, sir, he is.
Now, I call your attention to Exhibit 6. It's in the commission's book. It's the smaller of the two. Look behind tab 6.
Okay.
You have tab 6
Yes, sir, I do.
and March 25th, 2020 letter, is that correct?
Yes, sir.
Now, is this a letter that you received from Dr. Fontana?
It is.
Was this after your Skype telephone conference?
I believe it was, yes, sir.
What did Dr. Fontana tell you in the telephone conference?
That they had lost their accreditation and could not do what they signed up to do.
Now, had you ever had this situation come up before?
I have not, no.
Looking at exhibit number 6, the next to the last paragraph, it says, "as agreed," do you see that?
Yes, sir.
Would you read that, please?
As agreed, we will subcontract all samples received after 3/17/2020. We will notify you of the identification of an appropriate laboratory that can accept 3 samples with your authorization, ship them for testing. We will complete and report results for all samples received prior to 3/17/2020.
Now, was that an accurate statement of what was agreed to with you and Dr. Fontana?
Yes, sir.
And did you have any conversations with anyone else in state government concerning this issue?
Yes, sir. I was visiting with procurement the whole time because we were kind of in a position, we had a lab that had gone bad on their testing. We had to do something in the middle of racing season. So we found out what options we had, and we only had 2. That was A&M and Industrial. And A&M didn't do all the testing that we require. So I got with procurement, was talking to a lady who had worked there for the state a long time, and I said, how can we get around, can we get a get a new bid out there? Process would take too long. So as we walked through it, the questions were asked and answered. She said we can do it this way and be okay, and that was what we decided to do, was continue to send our tests to Truesdale. They would ship them to Industrial. Industrial ship them back to Truesdale, and Truesdale to us. And Truesdale would bill us, and Industrial would bill Truesdale. So they paid, and that way we got around having to break up the whole deal in the middle of racing.
You got the letter, Exhibit 6, on March 25th, 2020. When are the races over at Oaklawn?
May 3rd or so, it was the first Saturday.
So you had a month and a week or so to go,
Yes.
a couple of weeks ago in the meet, is that right?
Yes, sir.
Look at exhibit number 7, the commission exhibit number 7. You see an email from Dr. Lokang,
I do.
and it says, "Good morning, Julie." Would you read that?
Yes, please send our samples from Oakland and Southland to Industrial Labs for testing. I discussed this with Smokey Campbell, and this is his decision. If there are any problems, please call him.
Is that an accurate statement by Dr. Lokang?
Yes.
If I understand your testimony, you approved the process of sending the samples to Truesdale, who would send them to Industrial for testing. Is that correct?
That is correct.
And then Industrial would bill Truesdale, and Truesdale would bill the commission.
Yes, sir, that is what happened.
No further questions?
Mr. Quattlebaum, are you handling this witness?
please. Campbell, despite this big load I'm carrying up here, I don't think we'll have that long. I won't be ready. I
He
need
needs a truck.
You're the director for the Arkansas Racing Commission, correct?
Yes, sir.
You act on behalf of the Racing Commission and did so in connection with all these facts we're talking about, right?
Yes, sir.
And you are the representative of the Racing Commission in that regard, correct?
In some fashion, yes.
So here's what I'm gonna do to make it as short as possible. I'm gonna go through some things you told us in your deposition and make sure that we can just affirm that was your testimony and it's still your testimony.
Okay.
You told us that the Arkansas Racing Commission must abide by the rules itself in order to strictly enforce the rules on trainers, owners, jockeys, and so on.
Yes, sir, I don't recall making that statement, but they do follow the rules. Maybe I did. Our answer is yes.
I'm happy to walk you through the testimony if you want me to.
No, sir, I'm okay.
Oh, okay. Number 2, the Arkansas Racing Commission did not follow the RMTC rules related to subcontracting in this case, right?
Objection. The Arkansas Racing Commission is not obligated under any law or regulation to follow the RMTC rules on subcontracting. That is totally, absolutely irrelevant.
Well, let's test the relevance of it.
I'm gonna allow it as we have been doing. Go ahead and just handle that.
Mr. Freeman, I'm sorry.
I'm done.
Mr. Freeman has said that over and over again.
Mr. Freeland's gonna stand up and gonna say that it's in the contract and the bid proposal 2 times in writing what the racing commission has to do. It says it right there, it can assign it or delegate it if it's done in consent with the other party in writing.
Duly
It
noted.
is in there, and there's no getting around it.
Well, we can handle that on closing or through another witness or through.
It is
reading.
impossible to ignore that.
I understand.
With
That's-
every witness that Mr. Freeland questioned in this case, we were gentlemanly enough to make an objection when it was appropriate, state the objection, and stop, rather than engaging in an argument on every objection.
Okay.
So I would appreciate the same gentlemanly conduct from you, sir.
Okay, I did not ignore the written terms of the contracts like your side's been
Counsel,
doing.
let's just note our objections for the record. Let's proceed with the witness.
Totally ignore the written contract.
Mr. Freeland, you can handle that on closing and other spots during this hearing. Let's plow on through.
Thank you, sir. I want to refer you, I handed you a copy of your deposition, sir.
Okay.
And I want to refer you to page 65, so we can address that comment. And I want to refer you to line number 17 on page 65.
Seventeen.
Right, I believe that's right. Let me double check here. Oh, I'm sorry, line 4.
Line 4, okay.
Yes, sir. The question was, what you're telling me is that you generally what you generally tried to do is follow whatever the RMTC guideline, follow whatever the RMTC guidelines are, right?
Yes, sir, I think we have to decide something to make a judgment call on, and that's what we,
Right.
okay,
I think we do that pretty close, yes. Correct, sir?
okay,
That was your answer.
okay.
Okay, that's why I asked you that question just a moment ago about whether you comply with the RMTC guidelines for subcontracting.
Okay.
Number 3, you did not know at the time that you were engaging in that discussion with Truesdale about its accreditation problem, that the contract between Truesdale and the state had a provision in it that prohibited subcontracting. You didn't know that, did you?
Probably didn't know the exact terms of it,
Right.
that's why I got involved with procurement.
Exactly. The Arkansas Racing Commission never considered, this is number 4, the Arkansas Racing Commission, acting through you as its representative, never considered an emergency procurement procedure for dealing with the accreditation problem.
Advice that I got from procurement was do it the way we did it.
Well, that's not my question, sir. If you'll refer to page 19 of your deposition.
Okay?
And I'm referring to line number 20.
Okay.
This is where you were talking about that procedure. Was there any discussion about an emergency procurement process? No, because the emergency process would be putting it up for bid at the time of that was just we couldn't do it.
I think that's correct.
Okay. Now, Julie Hagahara was the official state chemist for the Arkansas Racing Commission, correct, sir?
She, not the state chemist, no, maybe from Truesdale.
Right, from Truesdale.
Okay, she could be, yes, sir.
Okay. And Truesdale was the official testing laboratory for the Racing Commission in 2020.
Yes, sir.
Number 7, you were unaware that the contract that required that positive reports be signed by the expert who performed the supervisor directed the testing at the time you were engaged in this process of subcontracting to industry.
Do that again?
Yeah. You were unaware that the contract between Truesdale and the Racing Commission required that any positive report be signed by the expert who performed the test, supervisor directed the test.
No, sir, I was not aware of who had to sign for it.
Number 8, you have no memory of talking to anyone in industrial before they began testing the samples from Arkansas.
No, sir, I don't think I did. Dr. LeCain had experience with him before, had been at the state of Arkansas before, but he didn't know him through the years, so I'll let him handle the conversation.
Okay, you got no documentation from industrial prior to the samples being sent there.
They did just what procurement said to, so I didn't ask for it because I wasn't told it needed.
I understand that. My point is, it didn't happen. No matter why, you didn't get any documentation
I didn't,
from
no, sir.
industrial. Okay. The Racing Commission didn't get any documentation from industrial before they started testing.
No, sir, not that I'm aware of. Procurement may have, but I didn't.
Number 10, you had no direct knowledge of qualifications of industrial prior to samples being sent there.
Other than we were told they were one of the 2 labs that could take our products.
And there was no contract entered into between the Racing Commission and industrial.
Not that I'm aware of.
You were never aware of any contract between Truesdale and industrial.
Other than that's the way we decided it was gonna be done. That's verbal, I guess, but no written, I saw.
Well, the deal between Truesdale and industrial was between them, not you, and you weren't aware of whatever that deal was,
No,
correct?
that's correct.
Okay. The rule, this is straight out of your deposition, sir. The rules that the Arkansas Racing Commission is bound to follow require that any alleged infraction by a trainer be kept confidential until after the steward's findings and the penalties imposed, correct?
Yes, sir.
And confidentiality is important to the integrity of the process, right?
Absolutely.
And that includes confidentiality about an alleged positive test finding, correct, sir?
Correct.
Confidentiality is important because it can affect a fair and impartial steward's hearing, correct?
Correct.
And compliance with the rules is important to the integrity of the process, correct, sir?
Yes, sir.
It's important for the Arkansas Racing Commission's rulings to be consistent too, isn't it?
I think so, yes.
Okay. I'm moving right along because now we're up to point 20. People should be treated fairly and consistently under the rules of the commission, correct?
Yes, sir.
And the actions of the stewards and the commission.
Yes, sir.
No trainer should be treated differently because of who he or she is, right?
That's correct.
The stewards dismissed the Steve Hobby case, correct? We've heard that here in this hearing.
Yes, sir.
Oh, I want to make another objection. It is abundantly clear to the commission and anyone in the industry that the stewards are a separate independent body from the commission. Therefore, the only evidence of unfair treatment would have to be unfair treatment by the Arkansas Racing Commission, and there is no evidence of that.
Is that a relevance objection?
It is. It's totally irrelevant what the Board of Stewards have done. It's what the Arkansas Racing Commission does.
Duly noted, Mr. Quattlebaum, proceed.
Thank you, Your Honor. You're not aware of any case where the Arkansas Racing Commission has had a chain of custody problem with a primary sample and relied upon a split sample for an adverse finding, correct, sir?
No, I'm not, no.
And of course, you've done no independent research on your own or on behalf of the commission into the pharmacological effects of lidocaine on a horse, right? You don't have any reason to dispute the testimony of Ms. Hakahara that the primary sample is of paramount importance, have you?
Do what now?
You don't have any reason to dispute the testimony of somebody like Ms. Hakahara that it's the primary sample that's of paramount importance.
I'm not gonna dispute it.
You don't have any reason to dispute the testimony of Ms. Hakahara that you don't even get to the split sample if there's a problem with the primary sample.
Correct.
Campbell, I want to run through some facts. And I apologize if any of this is repetitive. It's not going to take us very long. And I won't make you do a true false. Most of these we just covered. The Racing Commission is a commission under the authority of the State Department of Finance and the governor, right?
Yes, sir.
Subject to the governor's orders.
Yes, sir, I think so.
Mr. Campbell, you're the director, you're appointed by the governor, and you serve the commission.
Yes, sir.
Okay. The invitation for bid that we've looked at in this case was issued by the DFA, Department of Finance Administration, Division of the Racing Commission, correct?
Correct.
The purpose of the IFB, the invitation for bid, is for drug testing services in this case, right?
Yes, sir.
The IFB contained requirements 1.5 and section 2, and some of those were to ensure reliability. I went over all that with Mr. Fontana yesterday.
Yes, sir.
Truesdale submitted its response to the IFB, which we introduced as Exhibit 29. Remember that?
Yes, sir.
It included sections on qualifications, lab experience, facilities, management overview, resumes, knowledge of equine chemistry, and accreditations, all badges of reliability, correct, sir?
Right.
The contract for testing was awarded to Truesdale for the 2020 meeting, right?
Yes, sir.
All the terms in the invitation for bid were incorporated into the contract by the contract's term, right?
Yes, sir.
The reliability of testing is an important part of the contract, correct?
Yes, sir.
And that's why the IFB, the response to the IFB and the contract contain provisions about qualifications and such, correct?
Yes, sir.
And the owners, the trainers, the jockeys, and the public depend on compliance by all the parties with the contract provisions.
Right.
The integrity of the sport of horse racing depends on compliance with the requirements of the contract.
Yes, sir.
Truesdale lost its accreditation, and it could no longer comply with the accreditation requirements under the contract, right?
Correct.
You were informed of Truesdale's loss of accreditation in your role as director of the Arkansas Racing Commission, correct?
Yes, sir.
You were acting on behalf of the Racing Commission when addressing that problem.
Yes, sir.
The Arkansas Racing Commission did not enter into any agreement with Industrial, right? There were no written terms between Industrial and the ARC,
Not that I'm aware.
no written contract, no invitation for bid,
None.
no submission of qualifications by Industrial,
None.
no certification of compliance by Industrial.
Correct.
The Arkansas Racing Commission did not authorize Industrial to sign anything certifying a positive finding.
That's right.
After that, Industrial began performing testing through Truesdale, correct?
Correct.
Arkansas Racing Commission didn't obtain any of the following from Industrial: resumes, protocols, lab certificates, or accreditations.
No, sir.
Arkansas Racing Commission didn't find out whether Industrial's accreditation had ever been suspended or not.
No, we didn't know. No, sir.
Arkansas Racing Commission didn't require Industrial to read the IFB that Truesdale had responded to.
We did not require them to do anything.
Didn't require them to certify that they would comply with the terms of that IFB.
The way we followed the path of procurement, we didn't have to.
Arkansas Racing Commission didn't get written or verbal confirmation that Industrial was even aware of the requirements of the IFB.
Okay.
Campbell, let me hand you. Yesterday, when I was questioning Mr. Fontana, I asked him about those last 2 pages of his response to the IFB, which was the form that they're required to fill out in order to comply with the governor's executive order. remember that?
Yes, sir.
It's Exhibit 26 is the IFB response. It's the last 2 pages of Exhibit 26 where they filled out the form.
29.
Yes, sorry, 29. Exhibit 29, and it's the last 2 pages of Exhibit 29.
Mr. Quattlebaum, is that what you handed Mr. Campbell?
No, what I handed him is the basis for that, which is the proclamation or executive order of the state, of the governor. And we'll mark that as an exhibit, it'll be our next number. There are disclosure requirements required by, and this is Executive Order 9804. It requires that agencies require as a condition of obtaining or renewing a contract, agreement, and so on, that any individual desiring to contract or be employed or receive grants and so on with the state agency shall disclose whether that person is a current or former member of the General Assembly. It goes on, that you got any employee who is related to, a spouse of, they gotta require that from non-individual entity desiring to contract. Here's my point, sir. You didn't get a certification like that in compliance with the governor's executive order for any subcontracting relationship with industry. You would have left that up to somebody in procurement to make sure that that requirement for subcontracting was complied with under Arkansas law.
Yes, sir.
And nobody did it to your knowledge.
Not aware.
And that requirement was set forth by Governor Huckabee in 1998 and has been in place, as far as you know, since then.
Yes, sir.
I got 2 short points to finish with.
You want to enter that real quick, Mr. Quattlebaum?
Yes, sir. I think we're
64?
at 64.
I've got
Mark it
64.
64.
Any objection to
What
that?
is 64?
That proclamation.
9804
Well, I
proclamation.
have an objection to relevancy. It does not apply, and the contract doesn't require it.
Duly noted.
You know, it can be introduced.
Your relevance objection is noted. Thank you.
In addition, I'm going to make a record that the contract says that the state may waive any other conditions or terms of the contract that is in writing. in the
Counsel, I know I'm not a
contract.
circuit court judge, but let's just try to make it based on relevancy and
Well,
normal
I
objections
need to
noted for the
make that
record.
objection.
You're gonna have Mr. Kimball back in just a second to ask him those questions.
Did you obtain a waiver of that requirement, Mr. Campbell?
I did not.
Mr. Campbell, what we have here is Exhibit 27. It's the order, the ruling. On report of Truesdale, and this is the ruling with regard to Charlatan, and Exhibit 28 is the ruling with regard to Gammie. You're familiar with those, right?
Yes, sir.
You would agree with me that under everything you've heard about the fact that the lidocaine has no effect pharmacologically, it didn't change the performance of the horse. It's a harsh ruling. It may be black and white, but it's harsh, right?
Well, I'm not a scientist.
Wait a minute, I'm going to make an objection. Mr. Campbell, or almost no one in this room is qualified to make that statement. He has not had the knowledge to make that statement. And you can't ask a layman a statement like the drug testing.
I'm gonna allow it. You can certainly ask him and clean that up when you get him back in just a second. Go ahead, Mr. Quattlebaum.
You understand, it's severe, right? A disqualification.
Yes.
Okay. Here's the point. when the process requires integrity. Fair?
Okay,
Right?
yeah.
Okay. And it's not whether or not, it's not necessarily whether or not a seal was broken on a tube. It's whether or not the process underlying the order was fraught with problems. Do you see the point?
Well, I see what you're saying, but I don't know where there's any problem.
That's fair enough. That's why we're here. Now, we argue about the significance of problems if we want to. I don't want to. I just want to note what they are. The subcontracting, the contract has a provision that addresses subcontracting, right?
Okay?
We can argue all day about whether or not there's another provision that allows it or doesn't allow it, but it has a provision that prohibits subcontracting.
But I think
It says you can assign.
okay.
Okay. My point is, it has a provision addressing subcontracting, right?
Yes, sir.
Okay. There was no due diligence of industrial, right? That's at least an issue.
I didn't do any due diligence.
Under the-
Procurement probably did, I don't know.
You don't know? We don't have any evidence of any due diligence.
I wasn't asked to get it.
Okay. So the process of subcontracting and going through due diligence in order to perform the subcontracting are problems that have arisen in this hearing.
From your standpoint, yes, sir.
Yes, sir. There was no confirmation by industrial of protocols, qualifications, equipment, et cetera, right?
Yes, sir.
Okay. There is no certification of results in this case by a chemist who performed the test, right?
I just got the results.
Right, for Ms. Hackett,
Yes, sir.
who didn't perform the test,
We did.
or supervise it.
All right, sir.
We've got the facts about the cooler being shipped to Truesdale first and being opened, and the seal of the cooler being broken. Had to be.
Yeah, I think that's part of the process to make sure it hit ice and the whole deal when they transported it to the
Right.
production.
We got all those questions that we've gone over, and I don't want to go over them with you again about chain of custody.
Okay.
Okay. We got the gelding versus colt issue, right?
Yes, sir.
That was an error, correct?
Seems to be, yes.
In the process.
Okay.
We got the whole issue about the first report coming from Truesdale, reporting it clear. That was an error in the process.
Okay.
We've got the breach of confidentiality that may have occurred, appeared to have occurred before the stewards here.
Maybe, yes.
We've got as far as the evidence shows, the non-compliance with the governor's executive order, right?
Okay.
And so, the integrity of the process for those harsh, severe sanctions all over it. There are problems with the integrity that at least create an issue regarding the process that led to those sanctions.
Yes, sir.
That's all I have, Mr. Campbell.
Mr. Freeland.
Just very briefly, Mr. Campbell, have you ever read the RMTC guidelines?
I probably have, Byron, but I don't recall much of it.
Are you ever aware that the RMTC guidelines have ever been furnished to the Racing Commission?
Been furnished?
Yeah, to
They
the commission.
are able to look at them, they're there, yes. You want them to read them, you can read them.
Does the Racing Commission currently have a contract with Industrial Labs?
Yes, sir.
And did you hear the testimony of Peter Hartman from Industrial Labs? Peter Hartman testified they tested the samples from Convene in Charlton and they tested positive for lidocaine.
I did.
That's all I have.
Mr. Robertson, Mr. Quattlebaum, anything further? Commission, questions for Mr. Campbell?
Mr. Beeblum, Alex, oh, I remember, and I'm just trying to figure out where it came into play, that, and this was during the height of the pandemic, is that correct? Ballpark?
Yes, sir.
We might be having another height, I don't know. And was somewhere in there, I recall them saying, there were only options that we had was Texas A&M and Industrial Labs.
That's correct.
And Texas A&M was not capable of performing some of our.
Cobalt is another
That we
example
require.
we do, yes, that we require.
And Industrial Labs was the only one that was available that could do the test.
Dr. LeCank set out inquiries around the country, and nobody was taking new clients except those two.
Thank you.
Any other questions from the commission? Mr. Quattlebaum?
No, sir.
Mr. Freeland?
No.
Anybody else? Questions? All right, thank you, Mr. Campbell.
Yes, sir.
Mr. Freeland, is that your last witness?
Is our last witness. I think the commission wants to ask Mr. Baffert some questions.
Certainly, do you want to just, how do you want to handle that? You just want to,
I was gonna call Mr. Baffert, so he was gonna be my next witness.
okay, Mr. Baffert was sworn yesterday, as I recall.
That's fine.
Just for the record, and I understand that we're gonna proceed, but just for the record, in case there's appeal, I just wanted, at the close of their evidence, renew my motion to dismiss. I understand we're gonna keep going, but I just don't want there to be any vagaries on that for the record, in case there's a.
Thank you. Certainly, you had a motion to dismiss. Is there any other motions pending? Just for the record.
I think there's a motion to dismiss, and then a motion to void invalid test results.
In limine, is there any
Yes.
limine? Okay. And Mr. Baffert, let's take the witness stand, I suppose. Mr. Robertson, you're going to start?
Yes.
Okay, fair enough.
Was Mr. Baffert, were you sworn in?
He was sworn yesterday. I don't think we need to do it
Yes,
again. He
okay.
was sworn
Okay.
yesterday.
Can you state your name, please?
Bob Baffert.
Mr. Baffert, how long have you been training horses?
I took out my first license in 1971 as a trainer, and just was trained different years. In 77, I started probably getting serious about it.
How long, we've heard about two horses, Charlatan and Gamine. Let's take them one at a time. Charlatan, how long has Charlatan been in your care?
Charlton, I got him as a 2-year-old in the summer, in his 2-year-old year. And Gamine, I got her about the same time.
Have either Charlatan or Gamine at any point in time ever been prescribed lidocaine by your veterinarian?
Never. We don't even give lidocaine. We don't use, my vets don't even carry lidocaine.
To your knowledge, have any of your employees or anyone associated with your stable ever given lidocaine to the horse?
No, sir.
Is lidocaine something that is even kept in your barn?
No, I feel we run a pretty tight ship and very proud of my operation. And, we all know that we don't keep anything like that. Everything's, California's pretty strict. Everything's labeled, so there is no lidocaine in the barn.
Both Charlatan and Gamine raced here at Oaklawn Park on May 2nd, 2020, right?
Right.
Was either horse sore, injured, or hurt in any way before that race day?
No, sir.
Was either horse given lidocaine to deal with some type of soreness, injury, or anything else?
No, sir.
Were both horses healthy before their race on May 2nd?
I would say they were very healthy.
How did you learn, how were you told that Charlatan and Gamine had supposedly tested above the threshold for lidocaine?
I got a call, I had a message, I didn't see it till the next day, from Bernie Heidel to give him a call. And I called him on a Saturday, and then he told me that these horses had tested positive. And I would say I was pretty upset about it. You know, I didn't understand, you know, how could that be? He told me it was, what was it? He told me it was lidocaine. And so I happened to be in the barn, and I walked over. Jimmy Barnes, I went and found Jimmy Barnes, and I asked him I explained to him what had happened, and I was saying, what did you do? What did you use any? What's going on? You know, we're trying to figure this out because it was pretty tough call, and so because that just doesn't, you know, that's not part of what we are, and so we were just really just scratching our heads. I mean, I was thinking somebody got to these horses. We're trying to figure out the answer, and so and Jimmy could not think of anything. Of course not. He was upset. Of course I wouldn't, you know, use lidocaine or anything. You know, we didn't do anything differently than we do. Because we run a, you know, we run a, you know, big races, and we're very careful, and so it was pretty tough call.
Subsequent to that call, did you learn any further information from Jimmy Barnes?
Well, I did ask Bernie Heidel. I said, Bernie, this is, you know, and Bernie sort of felt bad about it, but I said, Bernie, was there any other lidocaines that day? And he said, no, there wasn't, but there was some earlier than me, but they were below the threshold. Because my mind's going 100 miles an hour. I'm trying to figure out what happened here. This is a very serious situation. And I asked Jimmy, and Jimmy, he didn't know until the next day. I believe it was on a Sunday. He called me up and he said, you know what, I just realized that I was wearing these Salon Pop patches that he'd gotten because he'd had a broken pelvis a couple of years before. And he said that he felt horrible because he was in the shower, he came out and he saw the box and he saw the lidocaine on it. And I said, you know what, it could have been me. And it was possible that it could have been me because I was wearing those patches. And I said, why were you wearing them? Because my back and it was hot. But he wore them on Thursday morning and Friday night. And what he did, he said he kept moving them, but he was tying their tongues going to the track. When we gallop a horse, we tie their tongues. So then I thought, well, you know, maybe it's possible, you know, that it was Jimmy.
And so Mr. Barnes testified at the Stewart's hearing to that effect, correct?
Yes, he was, you know, very upset. You know, he couldn't believe, you know, he would. I mean, Jimmy's been with me forever. He's one of the best assistant trainers out there, and it was really hard on him. And but it was, you know, something that, you know, at least, you know, the possibility that happened, at least we were getting something more.
Trying to figure it out.
Trying to figure it out, because it was just very upsetting.
Since that time, have you learned other information to suggest the other possibilities that perhaps it wasn't Jimmy?
Well, you know, the possibility was Jimmy, but then when I heard, you know, finally, much later, that there was another horse in the race that tested for lidocaine below the level, then we got to thinking, well, you know what? Jimmy sure didn't tie the tongue of that horse. You know, then I started.
Objection here. He said, I heard, and I know we don't keep that hearsay, but I want to, this is the grossest form of hearsay that he heard.
Okay, I was told.
That evidence has been is in the record
Fair
about
enough.
this.
That evidence is
Hearsay
not in
objection
the record.
noted, it's overruled, I'm gonna allow the question.
Well,
answered.
we allow hearsay, but
Absolutely.
I mean, it's so blatant, I just want to make sure I have a record to go to court.
Can we just refrain from argument? please.
You do yours and I'll do mine. I'll take care of the
Yeah, counsel.
commission's business and you take care of your client's business.
Okay,
You
counsel.
don't tell me what to
Counsel,
do.
it's been a long hearing. Let's just
Thank
keep
you, Mr.
plowing
Freeland.
through with Mr. Baffert. Thank you.
Okay.
Please
I was
continue with your.
told that there was another horse in the, so then that made me, well, think, well, you know what? Maybe, you know, it wasn't Jimmy Barnes, because that is just odd to me, that, and I had another horse that won the other division of the Arkansas Derby, and he had both horses, and he had 0 lidocaine, thank God. And so, it's one of those things where I don't know if we'll ever know what happened, but those horses were definitely, and, you know, I feel, they were contaminated that day because Jimmy did not wear the patches the day of the race, or, you know, and he had no reason to lie to me. He actually didn't even have to say anything. That's the integrity that he has, and so, unfortunately, here we are. I never thought I'd be, you know, here. It's been, you know, very emotional, and it was been tough, and, you know, those horses ran so hard, and for something like this to happen, it's just tough.
Thank you, Mr. Bradford. I don't have any more questions.
I know the commission called the witness, but Mr. Freeland, do you want to ask questions first? I'm going to give you first.
I'll make it very brief. Mr. Badger, are you familiar with the absolute insurer rule?
Yes, sir,
And you are the registered trainer of both Gamine and Charlton, is that correct?
yes, sir.
And you realize that as the trainer of Gamine and Charlton, you're absolutely responsible for the content of any test results that come back in those horses?
I'm responsible for anything that I have control of, yes, sir.
And we know for a fact that there was lidocaine in your barn through Mr. Barnes, is that correct?
Yes, sir.
And you race in several different states, is that correct?
Yes, sir.
Are you familiar that almost every other state has a threshold level for lidocaine?
Well, lidocaine's not even, I wouldn't even think of using lidocaine, so I don't even look. You know, we follow, we go to every state, we know exactly what the rules are, and, we obey them, and that's how we run our operation.
Now, you made the choice to choose the University of California at Davis to do the split sample, is that correct?
Yes, sir.
Have you used the University of California at Davis before?
Yes, sir.
Do you think it's a good lab?
I think it's a very good lab.
Did anyone pressure you, the Arkansas Racing Commission, to choose the University of California at Davis?
No, I think they only gave us a couple of choices there.
Now, you talked about, you trained Gamine and Charlton for some time. Has Gamine had other positive tests?
Yes, sir.
Positive tests for what?
She tested in Kentucky for betamethasone, and it was, we treated her with it. The rules were 14 days, and I treated her 18 days out to be safe. And they still, you know, at these levels they're testing at these picograms. And they picked her up, and we resolved it because of the mitigation, you know, circumstances. But it was there, because, you know, California, anytime you treat a horse, everything is written down. And unfortunately, we treated her, and she had like 25 picograms, whatever it was, and it was unfortunate, but you know, that's what happened there.
Was Gamine disqualified from the race in that instance?
She was.
Any other positives by Gamine or Charlton?
Anyone?
Any other positive tests for Gamine or Charlton?
No, sir.
That's all I have.
Mr. Robertson, anything?
Yes, just on the Gamine, betamethasone. Betamethasone is a lawful medication, is that correct?
Yes, it's a lawful medication.
And was it prescribed by the veterinarian?
Yes, the veterinarian prescribed it. And, it was, you know, the stand down is 14 days.
I want to make sure we understand when you stand down 14 days, what you mean is that it's recommended that you not give betamethasone within 14 days of a race day.
Yes, sir.
Okay. And so what did you do, or what did your veterinarian do in this case?
I specifically told them, I don't want to be, I've always been, I feel like I'm a very conservative trainer, and I don't want any issues, and I want to go 18 days. I don't want to be close to 4. I want 4 extra days.
So the betamethasone in that case was administered by the veterinarian,
Yes, sir.
18 days out,
Yes, sir.
and there were veterinarian records to show that?
Yes, sir.
Okay. And that matter has been resolved, correct? That's all.
Mr. Freeland, one more time, do you want to?
You say it matter's been resolved, that Demeen was disqualified from the race and unplaced, is that correct?
Yes, she was.
Okay, that's all I have.
There was no appeal taken in that case from the steward's ruling, correct?
No appeal.
Anything? Mr. Allen, anything?
No, sir.
Commissioners, question for Mr. Baffert?
That was a question I was gonna ask that Byron asked. So I'm good.
Any other commissioner?
Yeah, Commissioner Hunter, what, the medication that was given for, you mean, for the subsequent disqualification, what was that treatment for?
It was for her, it was for sheep, it was for her hawks, and that's what it was for.
Thank you.
Is that a painkiller?
No, it's a steroid that, they mix it with, hyaluronic acid, and she was, he explained, you know, that would, you know, she wasn't lame or anything, but, he thought it would, you know, it would help her, and, so, that's why, you know, so, that's what she got, that's how we treated her.
Go back.
On Gamine, what did she, amount did she testify before the fact?
I want to say it was 25 people, man. It was pretty low.
I don't know, I don't know what the cutoff there is, do you, offhand?
It was 0.
Zero tolerance?
No, no.
Was it 0? No?
I mean,
I think
the
it was-
betamethasone is your understanding, it's a lawful
Yes.
therapeutic, there's a threshold with betamethasone.
I'm not sure. That's my email.
Well, if you want to clean that up.
I didn't speak here, but he,
Commissioner Post, I think you're correct, there is a threshold.
I was, there was no appeal on the Gamine?
No, sir.
Is there a reason why there is no appeal on Gamine and there's an appeal on Charlotte?
Well, the reason, I really don't feel that we did anything wrong. I think they were contaminated. And with Gamine, I know what I did. I just came forward, this is what I did, and it stayed in their system, and they don't have the science right, you know, and that's, I really think a lot of trainers were sort of lab rats. I mean, with the atmosphere that's going on in racing right now, you know, they test us harder, stiffer than Olympians. I mean, you know, and so, you know, when you get down in the picograms, now you're really, you know, and I believe in strong testing. You know, I want to, you know, we got to, you know, catch the bad guys. But what's happening is that this picograms and this for medications that or contaminations, it's getting tough, you know, and so that's why we're here today.
Now we have the federal government to help us.
Yeah, we're the federal government, we're here to help. Those are the words you never want to hear.
Yeah.
Steve Landers, Mr. Baffert, why would they have a threshold for all this stuff if it's not, I mean, who made that law? Why is the threshold just, you're all trying to act like it's not really there, but there is a threshold, and somebody else made that rule, and it had to be questioned, that's a question. The threshold.
I don't know that he would know why, but
Yeah, I think at this point, Mr. Baffert is the witness, Mr. Landers, Commissioner Landers. Are you asking?
He's
Well,
asking
Are you
Mr.
asking
Baffert.
Mr.
I'm asking Mr. Baffert, why, I mean, the threshold is 20, everybody knows it. Everybody that's in the racing, I didn't know what the threshold was, but I'm talking about if that's the law that's been put out there, is there not something that should be done to change the rule, the law, the amount, if it's not meaningful? Well,
Well, hypothetical, I mean, I think it's cases like this, it gets their attention, say, what's going on here, you know, but, it's sort of, to me, I think the levels are ridiculous, what they're testing for, and I think these labs compete with each other, how low can we go? I mean, I'm like you, I've learned a lot in this, you know, the science, I've never really paid attention because, you know, if they say you can get dissolving 24 or 48 hours, well, I go 55, 60. I don't even want to be close. You know, I can't, I don't want any problems. And so, because we're, you know, high profile barn, and when something happens to me, it's going to be everywhere. And it hurts racing. So I think these, they haven't caught up with the science with, you know, I've seen it happen in California, you know, they have different rules. Everybody has different rules, like, it's just something I think that racing just hasn't caught up.
so California doesn't have the 20 picograms rule?
I don't even know what they have.
Yeah.
I don't know. I know betamethasone, they wouldn't have disqualified the horse.
Versus what happened in Kentucky.
That wouldn't have been disqualification in California.
And does California go by California rules or RMTC or whose rules do they follow?
I don't know.
That's an unanswerable question.
I can answer it if you wanted me to, but I don't think I'm allowed to do it.
Let's stick with Mr. Baffert.
Okay.
Okay.
That's what he wasn't sure.
Thank you.
Anything else, commissioners?
Yes, I do. Mr. Buttross. Mr. Baffert, dealing with the amount of money that's involved in this race, has your owners pressured you to be here today?
No, sir, no, not at all. I mean, I'm here because I just feel, you know, something went wrong. And when Jimmy Barnes came through, you know, told me about that, well, that's when we thought it was possible. But we know for sure that we did not administer it. We didn't give lidocaine. So it came from somewhere. And when he said it could have been that, and then when we heard about another horse, then I thought, well, something happened that day. And my other winner had 0. So something happened. But like I said, you know, I'm the trainer of record, and I'm responsible for it. But I'm only responsible for things that I can control.
If your horse would have placed 7th and it would have been pulled in as an alternate to be tested, would you have spent the money that you have spent so far on this to be here today?
Well, I wanted to clear my name because we don't operate that way. You know, I'm here because I showed up here because I wanted to be able to see what was going on, explain to you people that, you know, I feel like I'm very proud of my operation. We run a tight ship, and we would never, you know, try to take some kind of edge like that. I abide by the rules. I've come here. I love Arkansas. There's a statue out front of my best horse I've ever trained, and you know, I really enjoy coming here.
Thank you, sir.
Would it be fair to say, though, that if it was Jimmy, wouldn't it have shown up in the other horses, his other races? Because, I mean, it wouldn't just stop from Gamine, but maybe your other horses. Am I making sense?
Well, I think when it shows up in another horse that was in the same race, that, to me, that red flag came up, you know, and so those horses got contaminated.
Yeah.
That day somehow, but I don't know if we'll ever know.
Yeah, okay.
Commissioners, any further questions?
I'd like to just make something out. we're not here to question anybody's integrity, period. And we get rules thrown at us and said, these are the rules. And then we have to, other than Mr. Post coming up on drugs, I was just a medic, not a dentist, so I think somewhere, it's like I asked Dr. Cole, was that her name? And I think, did she say that she thought it was possible that it could have came from the salon patches? I'm trying to recall. But again, then you had Gamine, but then you had, forgive me, I can't remember the other horse's name, the one, but then he tested negative.
Right, that's in the dog.
And that's there. Again, we kind of still come up with, okay, the rule says this. So we're all under the microscope. Because whatever decision we come up with, it will be controversial. And that's the state of the game right now, and I'm not sure, it's not that I'm not sure, I know it's not healthy. But like I say, the federal government sounds like they're riding to the rescue to straighten it all out. Anybody else have a question for Mr. Bradford? Thank you, sir.
I think Mr. Robertson might want to.
Just a few things to make sure we're clear on. That day, May 2nd, 2020, you had Gamine Racing, Charlatan, and Nadal.
Right.
Any other horses in that day?
That was it,
That was it?
yes.
Okay. And is it your understanding that betamethasone is an anti-inflammatory?
Yes, sir.
And it's a lawful medication,
It's a lawful medication.
and it was administered by your veterinarian?
Yes, he recommended it, and he prescribed it.
And in that case, there were veterinary records that showed that, and the vet testified to that fact.
Yes.
And in that case, you didn't appeal that particular decision. You just accepted it, correct?
I accept it, yes, sir.
Because the veterinarian had given the medication. That was one of the reasons why you just decided to accept it.
Yes, sir.
Even though you felt it was concerned, was 18 days out given, and you're supposed to be good 14 days out, but it had been given.
Yes, sir.
So you accept it.
Yes.
And in this case, there are other issues, and that's why you're appealing this matter.
Yes.
And are you also aware, Mr. Bafford, that the rules also say that mitigating circumstances need to be considered?
Yes, sir.
Thank you.
Mr. Freeman.
Mr. Bafford, you had 3 horses that ran on May 2nd, 2020, is that correct?
Yes, sir.
Gamine, Charlatan, and Nadal,
Yes, sir.
and 2 of those horses tested positive for lidocaine, correct?
Yes, yes, sir.
So 2 out of 3 of the horses that you ran at Oaklawn Park on May 2nd, 2020 tested positive for lidocaine?
Yes, sir.
Good, that's all.
Mr. Robertson. Commission.
One other question. Was there any type of sales effect from testing positive and being disqualified from the race affecting the price of the horse?
How's that question?
In other words, usually when a horse, you sold, well, if you win this or you win that, the price of the horse goes up on the contract. Was there any contract like that on the horse?
Well, yeah, most horses, there's bonuses or whatever, American Pharoah and stuff, they all have bonuses. They're just trying to get all they can, but, that doesn't, it doesn't affect what
I just want
Yeah.
everybody to understand.
yeah.
Anything further, Commission?
No, sir. No.
Mr. Robertson? Mr. Freeman?
No.
Mr. Allen?
Yes.
All right, in that event, thank you, Mr. Bafford.
Thanks for having me.
Mr. Robertson, are we to your 2 Zoom witnesses? Is that correct?
I just have one Zoom
We have
and
one
one
in person.
and one in person.
Okay. Commission, should we take a 10-minute break? We're 10 minutes till 11. Why don't we come back at 11? Will that be okay?
I've got a nod, yes.
I can use a 10-minute break. Thank you.
Herdman dog.
No, that's-
Sounds like this. I gotta get it all done. And I have to do, hey,
No.
just like I was.
Mr. Schultz.
Like I was General Motors. You got on me, said,
I
how
think-
do you know this?
Can you hear us?
I can't.
Oh, yeah, that's all we've got for sound until they fix their sound, so they get it louder.
Hang on just a second, Mr. Schultz.
Will do. Maybe a little loud. You don't have a bigger Bluetooth speaker? All right, Mr. Schultz, will you say a few things so we can try to hear you?
Sure. My name's Ted Schultz, and I'm in North Carolina right now, and the weather is very nice here.
Well said.
I think we're good with the court reporter. Mr. Schultz, my name's Daniel Faulkner. I'm the hearing officer. If you would raise your right hand, let's get you sworn in really quickly. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And just for the record, you're not in the room with another witness or on Zoom with another witness as we speak, correct?
No, sir.
All right, Mr. Robertson.
Mr. Schultz, we've got a couple of issues going on here. We've got some construction in the background and a smaller speaker than we originally had, so if you can speak up, I would appreciate it.
I'll do the best.
Can you state your name, please?
My name is Theodore F. Schultz. It's a funny spelling. It's S-H-U-L-T-S as in Sam.
What's your educational background, Mr. Schultz?
I have a Bachelor of Arts in Biology from Adelphi University, and then I went off to the University of Kentucky, where I achieved a Master's of Science in the field of toxicology at the Equine Center there, which was before the Gluck Center was built. And then after that, I got the bug to go to law school, and then I went to Brooklyn Law, and I obtained a JD in 1980.
How are you currently employed?
Since 1991, I've been the head of the American Association of Medical Review Officers. This is the group of doctors who basically review federally mandated drug tests for the Department of Transportation, the federal government, and the NRC. So they're basically all physicians, and they also have to be trained in toxicology and the regulatory issues, what they can and can't do as medical review officers.
What are your job duties?
Well, my job duties is basically, one of the things that we do is we provide a monthly newsletter to MROs and stakeholders in the field on what the current legal and technical developments are with drug testing. I also basically have to run the curriculum for the course, which again covers all the aspects of the testing. Then I also, we set the programs up and do the lectures. And over the last COVID year, I've been basically developing an online course for physicians to do this without having to travel.
Have you ever been involved in equine drug testing?
Yes, I have. When I was at the University of Kentucky, they had offered me a fellowship to come down there and work in their new toxicology department, and my job was to find a laboratory to work in. So basically, I ended up working in Dr. Tom Tobin's laboratory over in the Veterinary Sciences building, and they were at the time researching in the area of drug and urine testing for the racetrack. So his laboratory was doing the fundamental research, and across the street in those days was the lab that did the routine drug testing from the Red Mile and Keeneland and the other pari-mutual tracks that they had contracts with. And my job at that time was basically to study cocaine in horses, as well as a couple of the other, Lasix and review a couple of the other common drugs out there, develop a method for it, and also develop a behavioral pharmacology, a behavioral methodology to sort of judge the effects of these drugs on these horses. To it, I developed a method for looking at it from what's called a variable interval response testing. It's kind of like what you do with rats, how many times does a rat push the lever? So that was what I was doing. As I said, I got involved as an expert witness in a case that was supposed to be a doping case, but it really wasn't. It was something else. But in any event, I got at that point interested in saying, hey, I really should go to law school. So I went back to lab and said, I've got an announcement. Like, I was on a PhD track, but I was so anxious, I said, hey, I've got to go to law school. So I took the master's and left.
Are you the author of any books?
Yeah, I have a couple of texts out. I mean, one of the major texts in this field is the Medical Review Officer Handbook. It's in like its 10th, and it should be in its 11th edition, but with COVID and everything, and also the regulatory delays, it's still its 10th edition, which has been out there for quite a while. I have, again, so there are 10 earlier editions, which I was the primary author of. I've also written a book called The Occupational Desk Reference, that's many years ago. It was a general reference text in toxicology, and I had a co-author with that. And I've also written a number of chapters. And, so I think those are the main things. Of course, I've done a number of technical papers as well in both the fields of human toxicology and equine pharmacology and toxicology.
Mr. Schultz, what is meant by the term chain of custody?
Well, chain of custody is the terminology used to basically represent the documentation for the handling of evidence, particularly in this field, the blood and urine testing, or whatever specimens are collected from the tracks. And in my world, it's all the urine and oral fluid specimens that are collected from the donors.
And what's the importance of maintaining a proper chain of custody?
Well, it's sort of, I mean, I think the common denominator in forensics is that you basically need to establish the provenance. Where did this evidence come from? Who handled it? When was it touched? Et cetera, et cetera. And that has to be kind of like, that's precise. I'll tell you, when I first got involved in this field, it was back in the early 80s, and my laboratory at that time was a lab called CompuChem, and CompuChem had the contract for doing the urine testing for the Army. And I was brought in essentially because they couldn't win a case. They basically were getting paid all this money to do this urine testing with GC mass spec, pretty sophisticated, and then they got down to Fort Bragg, and they got their doors blown off of them. They just didn't have the sample handling, they didn't have the expert witnesses, they didn't have the documentation. So I was supposed to be the new sheriff in town, I guess. So my job was to go in there and straighten all that out and make sure that they would prevail in these cases that were pretty cut and drawn. And that's what we did. So one of the essential elements with that was establishing that you had a solid custody control form. Again, the military does it different maybe than all of us do it, but basically they have a group custody control form where one piece of paper covers 10 or 12 specimens, but essentially what you have is you should be able to reconstruct the handling and the whereabouts of the specimens from the moment they're sealed to the moment they show up in the laboratory and they're accessioned by the lab personnel.
And you may have just answered this with that with that answer, you may have just answered my next question, but what is a proper chain of custody?
Well, a proper chain of custody is one that basically, if you can reconstruct who handled the specimen, when it was handled, where was it, and where did that handler put it? And then who did the handler turn it all over to? Now, sometimes, you know, in this world, sometimes the holder can basically turn it over to a locked refrigerator, or to a locked cabinet, or it can turn it over to another personnel, who then has to sign that form to say, I picked it up from X. So X goes to Y, and that means that all of that needs to be duplicated on the paperwork.
What if some of the chain of custody documentation is missing?
Well, I'll tell you, this is something that's evolved and has become pretty much standardized in the forensic field. If you have a broken chain of custody, you have a real problem on your hands, because that's opposed to the fundamental integrity of the testing. And basically, for example, on the human side, Department of Transportation and Health and Human Services puts out a list to all the medical review officers into what suffices as a sufficient chain of custody. And they have what they call fatal flaws, and they have correctable flaws. Now, the fatal flaws are basically, you know, you get a specimen in the laboratory and the numbers don't match. Or you get two specimens in one sample, in one bottle. You get two custody and control forms with one specimen. Or you get a specimen with no custody and control form. When that happens, it's irredeemable. That's it. We're done. That's the way it's evolved. Because if not, this whole thing becomes a very different kind of process. So, you know, the nature of drug testing is you really want to have it clean, straightforward, and nothing have equivocal. You don't want to turn it into the Wizard of Oz. You don't want to turn it into science court or a legal debate. So that's how they maintain sort of the integrity of this, is by having pretty strict black and white rules that all the medical results can follow. You know, so you know when you get something and there's no paperwork is screwed up, or for example, I mean, even something that sounds pretty simple, if the collector custody control form, and there's no name who collected the specimen, that's done, that's a fatal flaw. So there's 7 of these or so fatal flaws, and there are a number of other administrative minor flaws, the collector wasn't trained, those kind of things that don't go to the essence of where the specimen come from, and, and who handled it.
Have you reviewed the chain of custody documentation, in this case related to the horses Charlatan and Benin?
Yes, I have.
And have you reviewed the deposition testimony of Julie Hagahara and Dr. Fontana from Truesdale Laboratories?
Yes, I have.
Were there any chain of custody issues that you found in this case?
Yes.
What were those?
Well, fundamentally, we start with the idea that when these specimens were collected, they were going to send them to a laboratory, which, unbeknownst to anybody in Arkansas, had already lost its certification, or its certification, I should say, was suspended, which in some ways is a difference without much. In any event, these specimens were collected, they were sealed, they were put into 2 containers, and then when it was discovered that they couldn't send it to the laboratory that was designated, they decided that there was a decision made, and you've gone through that, I'm sure, in detail, to send it to another laboratory. And so, for somehow or other, when it got to that second laboratory, or what they would refer to as the subcontract laboratory, the seals were different. They weren't the ones that were put on initially at the track or in Arkansas. And then on top of that, there doesn't seem to be any paperwork explaining who did it, when it was happening, et cetera, et cetera. So I think there's sort of 2 fundamental fatal flaws here: the breach of the containers, and then also no documentation even to show that. Now, whether it was taken or not and lost or whatever, it doesn't. At the end of the day, I don't know if that makes a difference.
And so you consider these to be fatal flaws?
Well, not only me. I mean, if this is a federal test, that would clearly be a fatal flaw. And I think mostly, I was involved for a number of years, looking at criminal labs, laboratories that do forensics for the criminal justice system. And they also have a pretty strict protocol that if you have a flaw, you don't want to go into a trial and basically not be able to establish, your custody control. So that would be the same thing. And again, as I mentioned, if this was a federal test, this would not have been reported. This would have become a canceled test.
And in your world, in your experience, if there's a chain of custody is broken on a primary sample, can you just use and rely on the split sample?
Well, one of the things sensitive to is that I'm not quite
I'm
sure.
going to make an objection for the record. Just a minute, sorry.
Hold on, Mr. Schultz, hold on.
He's asking him a legal conclusion, which he's not qualified to answer because he has not studied the Arkansas Racing Commission rules and regulations. Go
We're
ahead.
just asking that on cross, absolutely, for the record. Mr. Robertson, please proceed.
Mr. Schultz, do you remember the question?
Repeat it.
Sure. In your world, if the chain of custody is broken on the primary sample, can you just use and rely on the split sample?
Not in my role. And let me tell you something. When we established split specimen testing, this basically came out of all things Major League Baseball. They've had this established for years. We never got into it on the human side because it was expensive, it was additional work, all of that stuff. But Congress said, wait a minute, if you're going to do this under the auspices of the federal government as a mandatory program, you need to have a split specimen. This is a fundamental safeguard. So the idea, and the way DOT interpreted that was, okay, if that's the way it is, that this has really become a federal right. And on top, now again, this is humans, not horses, but at the same time, they said the bee specimen is the owner of the bee specimen is the donor. The donor is the only one who could authorize that to be tested, and you would never test that unless the A bottle was already verified as being, or confirmed as a positive test.
Thank you, Mr. Schultz. I don't have it.
So I guess
Go ahead. Go ahead. Did you want to add something else?
No, I'm fine.
Mr. Freeland.
Mr. Schultz, did you examine the
What I looked at was the industrial lab litigation package.
Okay, did you look at the University of California, Davis split sample litigation package where the University of California tested these samples?
No.
You testified that not in your world. Your world is criminal law dealing with humans, and the criminal laws of the United States are the military. Is that correct?
That's not the whole world. That's part of the world. The bigger part of the world is the civil world, where basically we're talking about public safety and the mandatory guidelines as authorized by the Supreme Court to test workers in safety-sensitive environments, from airlines to nuclear facilities, et cetera, et cetera. So that is not criminal, but that's civil.
Understand. I have no other questions.
Mr. Robertson?
No.
Mr. Allen?
No, sir.
Commissioners?
Steve Landers, Dr. Schultz, are you being compensated by the defense in this matter?
Yes.
I'm sorry.
Well, I just came up with a flat charge for this, just to do the whole shooting match for $5,000.
Okay.
Because it really, frankly, from my perspective, this wasn't a difficult case. Again, if I had to get into all the GC mass spec and do the ion ratios and all that kind of stuff, I would have charged more. But based upon the way it was presented to me, said, okay, I can handle this. And so that's where we're at. So they don't owe me any money. I don't owe them other than the rest of the time for this hearing.
Thank you, Dr. Schultz.
Other questions, commissioners?
Has your testimony been honest and forthright?
Yes, sir.
Did I or anybody else tell you how to testify or ask for anything other than your honest opinion?
No, you didn't.
So,
Mr. Freeland, anything?
No.
All right, in that event, Mr. Schultz, thank you very much.
thank you, Mr.
Thank you,
Schultz.
Dr. Schultz.
Well, thank you so much. All right, take care.
Mr. Robertson, your next witness.
Dr. Fingers, he's outside.
Let me go ahead. I'm Daniel. I'm the hearing officer. Let me swear you in really quickly before you sit down. If you'd raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Have a seat. Mr. Roberts.
Can you state your name, please?
Clara Fager, that's F as in Frank, E-N-G-E-R.
What is your educational background?
I'm a veterinarian. I did a bachelor's in physiology at the University of California at Davis. I got my veterinary degree in 1988 from the University of California at Davis. I then got a master's degree in equine exercise physiology at the Ohio State University in 1992. I also became board certified in internal medicine at the same time. And then I went on to do a PhD in veterinary science at the University of Kentucky, which I completed in 1996.
Are you the author of any scientific papers or articles?
Yes, I'm the author of approximately 30 peer-reviewed scientific papers and countless other articles.
Are you a member of any professional organizations?
I am. I'm the founding member and the secretary of the North American Association of Racetrack Veterinarians. I'm a member of the American Veterinary Medical Association, the Kentucky Veterinary Medical Association, the Kentucky Association of Equine Practitioners, American College of Veterinary Internal Medicine. There might be one or two others I forgot.
Have Have you been involved in any research studies which have examined the pharmacological effect of medications on horses?
I have.
Do you consult with pharmaceutical companies?
I've consulted for at least 9.
Are any of those veterinary pharmaceutical companies?
Almost all of them are veterinary pharmaceutical companies.
Do you own any patents?
I do. I have 1 patent for a drug and 1 patent for a diagnostic test in horses.
How are you employed, Dr. Finger?
I am self-employed. I have a consulting internal medicine, pharmacology business, hence the consultation with pharmaceutical companies. And I also am a private practitioner, so I also practice part-time.
Veterinary medicine?
Yes, veterinary practice equine.
Have you ever worked for a racing commission before?
I have. I worked for 15 years for the Kentucky Horse Racing Association, or Commission.
And what was your job with the Kentucky Horse Racing Commission?
I was a part-time state veterinarian.
Dr. Finger, you're familiar with the term chain of custody.
I am.
What's the importance of maintaining a proper chain of custody?
The importance of maintaining the proper chain of custody is that a sample, in order to be absolutely guaranteed to have been from a specific horse, there has to be an unbroken chain so that it's identified where the sample came from and every step of the way what happened to that sample, where it was, in order to avoid the possibility of inadvertent or intentional contamination of the sample.
Again, you were the assistant state vet for the Kentucky Horse Racing Commission for how many years?
15.
15. And in your experience as a regulator with the Kentucky Horse Racing Commission, what happens to test results when there's a broken chain of custody?
As a rule, when I worked for the Kentucky Horse Racing Commission, if there was a break in the chain of custody, the positive test would simply not be called.
What is a litigation packet?
The litigation packet is provided by the laboratory that conducted the test on the sample that demonstrates the chain of custody of that sample upon receipt from the laboratory, and then essentially everything that they did, or was supposed to include everything that they did from receipt to the calling of the final confirmatory test.
Have you reviewed the litigation packets in this case associated with Gamine and Charlotte?
I have.
Did you notice any chain of custody issues in this case?
There were a couple of significant chain of custody issues. The primary one being that there is a complete lack of chain of custody or loss of the samples, that basically the documentation is blank between receipt at Truesdale and then receipt of the samples at Industrial.
And in your experience, again, as a regulator, chain of custody is broken on the primary sample. Can you use a split sample instead?
Objection, you cannot ask a legal question. She's not competent to answer this. There is no law, and if there is law, they would present it to this commission, which they cannot do.
Mr. Friedland has presented no law to support what he keeps saying.
Same ruling as Mr. Schultz. Please proceed. Objection noted.
In your experience as a regulator, if the chain of custody is broken on the primary sample, can you use a split sample instead?
No.
What's the importance of properly identifying the sex of the horse?
There are different tests that are applied and different penalties applied to different substances in different sexes of horses.
Let's talk about the difference between colt and gelding. How are those samples analyzed differently?
The horse sample or entire horse sample would not be tested for anabolic steroids, and a gelding would.
Did you notice any issues with the identification of the sex of Charlatan in this case?
Yes, that was probably the first thing that jumped out at me when I looked at the litigation packet, that the horse was identified as a gelding.
And how does that impact test results? If a sample's actually from a colt, but it's identified as a gelding, how would that affect tests?
The horse would have had an elevated level of testosterone and possibly also nandrolone, 2 different anabolic steroids.
Did you see any documentation reflecting that this sample that supposedly came from Charlatan was called high for testosterone or anabolic
No,
steroids?
there was none of that, nothing it was indicated in the screening or confirmatory tests that any of the samples came back high for testosterone.
if in fact industrial in testing determined that Charlatan was an intact male, would you expect to see that documentation?
That would have to be in the litigation package.
If you could look at exhibits 14 and 15. This is exhibit 14, I believe. You have that in front of you?
I do.
Okay. And have you reviewed this report and then also the similar one, which is exhibit 15 for committee?
I have.
Okay. And did you notice any issues with these reports?
Multiple issues with those reports.
What specifically?
So specifically in the case of, well, exhibit 14, which is for Charlatan. The first issue is after seeing that the sample was subcontracted to industrial labs, the certificate of positive test is signed by Julie Hagahara, who is with Truesdale Laboratories. The certificate of positive is supposed to be signed by someone who was able to directly oversee and review all of the documentation associated with the positive test. And since Julie Hagahara lives in Irvine, California, and not Colorado, I know that that was not the case. She didn't oversee the testing. She simply got a report back from industrial. So, number one, that's one of the problems with the chain of custody. The certificate of positive, there's a reason. These penalties are severe for every drug positive, not just this one. Drug penalties are severe. There's a reason why there are very specific requirements that are put in place by and reiterated by the ISO 17025 accreditation, the ILAC G7 document that horse racing forensic laboratories are supposed to follow, and also the RMTC document that has been promulgated to every RMTC laboratory. And that is, you must follow these steps to absolutely ensure the integrity of the testing process. And this is one of the ways in which that has been ignored. We simply don't have the person certifying the test that had anything to do with the test or got to see anything in the process. It's possible, had Julie Hagahara been there, maybe she would have identified something that was amiss, but she can't. She cannot possibly identify anything because she wasn't there.
Any other issues that you've noticed with either exhibit 14 or 15, which are these positive findings signed by Ms. Hagahara?
These are simply the positive test
Notification letters.
notification letters, yes. And those would be that would be the main issue, that those samples are signed by someone who is not qualified to sign the positive certificates.
Dr. Finger, what is lidocaine?
Lidocaine is an amide local anesthetic. It's one of a class of maybe 20-something drugs. And it's used in veterinary medicine most commonly for numbing or blocking substructures, with the number one thing being if the horse gets a cut, that you want to put sutures in, that you first numb the edges of the wound so that you can put sutures in and sew the laceration. The second thing that it's used for is in the process of doing analgesic or clocks, basically, to determine as a veterinarian if the horse is, say the horse is lame, and you want to know if the lameness can be isolated to the foot. What you do is take lidocaine or another amide local anesthetic, and you infiltrate the nerves that innervate the foot. And so it numbs the entire foot. So then when I watch the horse jog the next time, if it's sound, no longer lame, I've now identified that the foot is the source of the injury, the lameness, the pain. Those would be the two main purposes that it would be used for.
Are you familiar with scientific studies related to lidocaine and its effect on horses?
Absolutely.
And are you familiar with the pharmacology of lidocaine in horses?
Yes.
And what is meant by the term pharmacology?
Pharmacology is the the characteristics of a drug, how it's absorbed, metabolized by an animal, and then eliminated and excreted, and the effects of both the drug on the animal and also the animal on the drug.
From your review of the litigation packets, and you've got the letters in front of you, what was your understanding of the levels of lidocaine supposedly found in Charlotte and McMinn?
In both horses, the level is well below any level that could possibly have any pharmacological effect on the animal.
To be clear, the Exhibit 14 shows 46.1 picograms of 3-hydroxylidocaine, correct?
Correct.
All right. And gamine is 185 picograms of 3-hydroxylidocaine?
Correct.
Okay. And are you saying that for both of them, that both of them are well below the level there could be any pharmacology?
That is correct. Both of them are well below, with charlatan being completely irrelevant in any way.
What's your basis for saying that?
So a study has been done, and it was originally conducted in the 90s by Dr. Tobin. Subsequent to that, I've been doing some work with Dr. Tobin on the related amide local anesthetic, bupivacaine, so very closely related. And so we've repeated some of this work, although it hasn't been published yet. And what we did was we determined the lowest amount of lidocaine and bupivacaine that can be laid directly over a nerve and have no effect. So that's called the high no effect dose. When the high no effect dose for lidocaine is applied to a horse, the total, and this is from the 90s, so we used a different technology than the mass spec, the total of lidocaine, 3-hydroxy, 4-hydroxy, and megax, which are the major metabolites, the total of all of those things had to be at least 840 picograms per mil. All of those metabolites combined in gamine, which is the higher of the two, are well below, it's about 250, 300, so well below this 840 cutoff level for the amount that would be there if I used the highest dose that does not have an effect. So 840 still wouldn't have an effect, and she's less than half of that. So that's, and then obviously charlatan being lower is even more ridiculous assumption that might have any effect.
This high no effect dose, this study was performed by Dr. Tobin?
That's correct.
And has that study been published?
Yes, that study's published.
Okay. And the determination from that study was that it was 840 of the lidocaine and its metabolites, that there would be no, that's the cutoff, 840 picograms.
That's correct, and they even actually came up with a level for 3-hydroxy of about, it's in urine though, of a little over 300. So at the time, a lot of things were regulated in urine. So in urine, it's 340, and in blood, and that's just of the 3-hydroxylidocaine, and in blood, 840, all of the metabolites combined.
Okay.
And that's a published study.
So to be clear, above 840, some type of pharmacology, below 840 picograms, no pharmacology.
Correct.
And let's talk about 3-hydroxylidocaine, which was found here. What is 3-hydroxylidocaine?
So when lidocaine is administered by any route, the animal rapidly metabolizes that into several different metabolites, the main one being 3-hydroxylidocaine. 3-hydroxylidocaine is then rapidly what's called glucuronidated. So an animal, this applies to all pharmacology. If you give a drug to an animal, the animal immediately starts working at trying to get rid of it because it doesn't belong there. And so one of the ways that they do it, in this case, is glucuronidation. So it's taking a sugar molecule and attaching it to a drug to make it more soluble so that it'll be eliminated in urine more readily. And so it's immediately glucuronidated. So the issue, and this is what makes this particular substance really curious from the way that we've decided to regulate it. So we're testing for an inactive metabolite that is glucuronidated in the blood at all times. Glucuronidation interferes with drug testing. So it's the only way that's used in drug testing laboratories. The only way to identify it is to cleave off the glucuronide. So the way that this is done is they take the sample, in this case a blood sample, typically it's urine, and they incubate it, in this case overnight, with an enzyme. So they add an enzyme that then cuts off this glucose molecule that makes it more soluble and eliminates that. And then what's left, they test to try to find the 3-hydroxylidocaine. What's curious about that is none of the screening tests use the enzyme, the glucuronidase enzyme. None of the screening tests in any of the labs for screening. So it's typically used in urine because, what did I just say? The reason it's put on there is in order to facilitate elimination in the urine. So a lot of things are glucuronidase or the parent molecule, lidocaine. So they're looking for lidocaine or the other metabolite, we call it MEGX. So then if it comes up positive for MEGX or lidocaine, then they would do the additional step. And why do they do that? Because it requires an overnight incubation, and it's going to massively increase the cost of the testing for the Racing Commission, and so they just screen for these other things first, and then only confirm the 3-hydroxylidocaine, which is all glucuronidated, once they have the screening test has told them that there's something in there to look for. So that's the significance of what happens to the 3-hydroxy.
Let's simplify this a little bit. 3-hydroxylidocaine, is it inactive?
The glucuronide is inactive.
The parent lidocaine is active, correct?
Yes.
And you can test for the parent lidocaine, can't you?
Yes.
Now, how confident are you, Dr. Finger, that these levels of 3-hydroxylidocaine in Charlatan and Gamine would have had no pharmacological effect?
110%. And again, that's based on the high no effect dose. We know that at 840 total, 340 in the urine, there's no effect on the animal.
Could this amount of 3-hydroxylidocaine that was found in either horse, could that amount correspond to a numbing effect sufficient to allow either horse to race on an injury or pass some pre-race inspection?
0 chance.
And why is that? For the same reason you just
The same
articulated.
reason I just said. The highest dose that you can put into a horse and have no effect gives you levels higher than these.
Do humans use lidocaine?
Yes.
Okay, and is there a risk for horses to be contaminated by lidocaine from a human or any environment?
Yeah, absolutely.
How much lidocaine from a human would be required to produce a level of 185 picograms in gamine?
So about the typical human cream to be 1/10 of a teaspoon.
And how much lidocaine from a human would have been required to produce the level of 46 picograms in Charlatan?
Way less than that, just the amount that could be on your fingers from touching the patch.
Do you have an understanding of the RMTC and the RMTC's recommended threshold of 20 picograms for lidocaine?
Very much.
And have you reviewed the scientific study upon which that's based?
I wish I had reviewed the scientific study upon which that's based, but that has not been made available to scientists, public, anyone. What we do have is a brief summary provided by the RMTC and some data provided by the RMTC.
So the actual study itself, the RMTC has refused to release to the public or any scientists?
There apparently has been no attempt to try to get that published or released in any way.
Based on what they have made public, what exactly have they made public that you've been able to review?
Well, they made nothing public, but in the course of this hearing, we were able to get a recommendation or comment from Mary Scalay, who is the executive director of the RMTC now. She was not at the time the study was done.
And did you review that information that they provided?
I did.
And what was your opinion or analysis? of it?
Well, so, for starters, I'm just gonna go back to, they made this a mandatory Class B penalty. I say mandatory, it's not, that's absent mitigating circumstances. But that's a pretty severe penalty upon which to base upon 6 horses, which is the total number of horses that they used to conduct the study. More curious is they started, when they first did the study, the lowest level that they could detect, so the limit of quantitation for the study was 100 picograms, so not obviously less than the sample for Gamine, but more than the sample for Charlatan. And I hope to get an opportunity to explain why some of that is as we get into the lab reports. But that was their initial limit of quantitation, was 100. And they decided, well, we have to have a lower level lower than that, so they went back and reran calibrators with the same samples in order to get a limit of quantitation of 20. And again, I'm expecting to explain that better as we get into the reports. So then they went back and said 20, and then all the horses were below that 20, again, we're talking 6 horses, at 48 hours. But they estimated the values below 20 for both 48 hours and also 72 hours. And one of the curious things is the levels at 72 hours were higher than the levels at 48 hours. Think about that again. The drug is given to the horse, it consistently goes down, and then it's a level that they've claimed that it's at, that they can identify, so they give you numbers at 48 hours, and then 24 hours later, these are research horses, so they shouldn't be exposed to any exogenous lidocaine anywhere. 24 hours later, the values are higher, the same or higher in 5 or 6 of those horses. So there's something very curious about their entire research project that was done. I don't get to look at what they actually did because they didn't publish that, and it wasn't included as part of this brief data packet that was provided to us from the RMTC. So all we know is something very strange happens to lidocaine as it gets down to very low levels. So if a person or a human or animal is exposed to lidocaine, once it gets down to very low levels, it possibly goes up and down, and that was not taken into consideration. It's possible that had they looked at the numbers at 72 hours, that their threshold would be higher. And that has actually happened with another substance that they did the same thing. Betamethasone, the threshold is one thing at 7 days, and at 9 days, it's about 4 times higher if you use their own data. So my point is, they don't take this possibility of drug levels going up and down once you get to the very low levels into consideration for any of their thresholds.
6 horses were used in the Iowa State study.
Yes.
What's the typical number of horses that are used in studies?
For threshold determination, well, for starters, the FDA requires at least 120 for their studies. And as a drug company consultant, I do those studies all the time. The RMTC specifically stated when they first started proposing thresholds that they were going to use no less than 20 horses in their threshold determination studies. And yet they've used 20 or more horses in only a few. And most of the thresholds, like this one, are using an inappropriately low number of horses.
You familiar with the sensitivity of modern day testing?
Oh, yeah.
And how does that compare to the past?
In the past, certainly, I'm going to say 20 years ago, if you could detect the substance, you were at risk of the substance being able to have an effect on the animal at the time it raised. Drug testing has increased over 1 trillion-fold since then. And now we're able to detect small amounts of any number of things. And just an example is, in order to make this simple, in humans, the human recommendation is for almost every, of course they don't test for lidocaine, but the substances of human abuse, such as morphine, methamphetamine, cocaine, they have threshold cutoffs. Because if they didn't, you could never hire anybody, and half of the people that work at this hotel wouldn't be here because of this environmental contamination. And it's not just people, that are susceptible to this trace contaminations of substances. Horses are as well.
Dr. Finger, want to be sensitive to timing here, and so I want to give you, I've got one final question, but before I do that, I want to give you the opportunity. You've indicated that there were other things that you wanted to explain in those litigation packets. If you could tell the commission, you know, what you believe that we haven't already talked about,
Right. I'd
that's
like to-
important in those litigation packets.
Where are they in here?
They are exhibits 8 and 9.
8 and 9, okay.
Exhibit 8 is Charlatans litigation packet,
So
sample 106032.
So let's turn to, off the page and then I'll let you know. So, with tandem mass spectroscopy, drug testing, the way that it works is it has a chromatography portion first. The only reason that has any meaning to you is that's where it separates out substances, so that instead of having just a clump of urine or blood, it separates it out into various substances, so that you can say this group of substances is here, this group of substances is here. So it's the first step in the drug testing is to separate them out so that you have different times at which different drugs can be concluded that this is what this drug is. So, and that's called the retention time. So the way that they identify drugs is they have a standard retention time. So it comes off the column at a certain spot. Let's say for the sake of this, it's about a minute. So it comes off the column in about a minute. And then the next thing that happens is whatever comes off the column goes into the mass spectrometer. So a substance has a certain mass or weight. So we know that each molecule of lidocaine weighs this much. And then the reason it's called a tandem mass spectrometer is that then that is sent into what's called a reaction chamber, which it basically bombards that parent molecule with usually electrons, but it could be other things. It bombards that so that it breaks up into component parts. And you know, I've used the example before of a house with a garage. You have, if you put the whole house in, this is how much the house weighs, this is how much the garage weighs, that's a daughter ion, this is how much the house weighs, it's the other daughter ion. So every ranch house is going to have a predictable parent mass and predictable daughter ions, the house and the garage. They have a predictable weight. So that's the...
Dr. Finger, I
I'm
don't,
getting to your- I'm just-
yeah, I don't want to interrupt you, but if we can, because none of us are scientists in this room, if you can just identify what problems you saw in either litigation packet and just in broad strokes and generally what the significance of that is.
I swear I'm getting there. So the key is lidocaine has 3 ions. So 251, that's ion number 1. So you have, we'll go to page 53 of 100. Maybe.
53. Yes. Oh,
Which exhibit is this?
exhibit 8.
So the significance, that works. 50, 55.
Well, this is really 53 of 100, it's just 0
Okay.
here, one second.
Okay, I got it. So here's my point, and I have to So 86, you see 3-hydroxylidocaine 86, 58, 251. So that's how we know this is lidocaine, because it has the parent molecule and it has the daughter ions that are required. So in the case of gamine, now let's go to the page before that, 52.
And this is Charlotte's litigation.
I'm sorry,
Exhibit A.
Charlatan. So the significance of this is, in order to call a positive, so let's just look at the blank and the negative, so the two in the center, the blank and the negative. So there's not just a flat line on the bottom, right? There's peaks. It goes like this. It goes up and down. And you can see the retention time is right about, you can tell from the other graphs, the retention time is right about 1 minute, which is right about in the middle of the graph on the x-axis. So in order to quantify a substance, one of the criteria is that the peak is greater than, and depending on which criteria you use, anywhere from 3 to 1, higher than the background. And why is that? Because obviously there's a background. In both the blank and the negative, there's a peak at retention time of 1. And now let's go to the top row, far right. That's the 10 picogram. And you see the computer does that. The computer does that blackening in. But you can clearly see that at 10 picograms, that's not at least 3, and that's using the most liberal criteria. That's not at least 3 times background. Let's go to the 15. That's not 3 times background. Let's go to 20. That's not 3 times background. Let's go to 50. That's not 3 times background.
And so what is the significance that something is not 3 times background?
It doesn't fit the requirements for calling a positive test. And the reason that those criteria are in place is because it's critically important that you know. How do you know that that's not just some spurious, odd thing that happened with the background? We know that there is background when there's 0 lidocaine in the sample. We know there is a signal to the machine that there's lidocaine there. And the criteria that, like I said, the most liberal criteria is 3. In some cases, it's as high as 10. And we don't have that till we get down to 250 or 1.
So are you saying, in your professional opinion, this should not have been called as a positive test?
Because you can't, this laboratory cannot quantify it below about 100. The charlatan test does not meet the minimum requirements for calling a positive test.
Thank you, Dr. Finger. I don't have any more questions.
Mr. Freeland.
Dr. Finger, what state do you live in?
Kentucky.
Does Kentucky have a rule for horse racing that has a threshold for lidocaine?
Yes, they have the RMTC rule.
So then that threshold is 20 picograms, is that correct?
That's correct.
The same rule that Arkansas has.
That's correct.
Isn't it true that most states have the threshold level of 20 as the rule for lidocaine?
Correct.
Basically what you're doing is you're stating, you're testifying despite the fact most, if not all states have the threshold level of 20 picograms, you're critical of that rule, is that correct?
I'm going to say that in the case of these samples, that they can't be called positive based on the 20 or whatever you want to choose for your threshold. I will tell you that I also have a problem with the 20 picogram threshold for 3-hydroxylidocaine.
Okay, that's very obvious that you're critical of the rule that most states have, is that a correct statement?
That is correct. There have been many errors made by the RMTC.
You talked about the chain of custody dealing with the samples that Truesdale handled. Do you have any knowledge whether or not the actual urine bottles and the blood vials had the seals broken on those bottles?
No.
You talked about the testing for a colt or a gelding. When you're looking for lidocaine, does the sex of the horse make any difference?
No, but if there's no testosterone in the sample with the lidocaine, it did not come from a colt.
Have you studied the Arkansas Racing Commission rules?
No.
Have you even looked at the rules?
The section pertaining to this, but that's not,
Section pertaining to what?
to this case.
Well, you looked at the threshold levels, I assume.
Correct.
Did you try to find any Arkansas Racing Commission rule on specific requirements for chain of custody?
No.
Now, there are no rules in any of these states that you're familiar with that require someone to prove that the drug had an effect on the race or on the horse. Isn't that correct?
That's correct.
So the Arkansas rule that you're criticizing, then you criticize the Arkansas rule, or you criticize this case because you couldn't show any effect on the horse or the race, but that's the rule in all states. Isn't that correct?
That's correct, although realizing a 2B penalty is put in place because it would be very relevant if the horse had an effect, had a drug that was capable of having an effect. I think it's a significant mitigating circumstance that it was well below that level.
Now, if I understand what you're testifying about, you said a small amount of lidocaine in the barn would have been enough to produce the test results we had for lidocaine in these two lab tests. Is that correct?
Yes, although I didn't get a chance to bring it up before, but the results for gamine indicate that the horse was likely exposed long after it left the barn, like when it was already in the test.
Now, were you aware that Mr. Barnes, Jimmy Barnes, the assistant trainer, was using lidocaine patches?
I am aware of that fact of case, but so are dozens of other people.
All right, and so that is a possible source of exposure to the horses. Is that correct?
That's correct. And again, the samples, the testing that we had done indicates that the exposure to gamine occurred after the race and in the test barn. I'm assuming Mr. Barnes was in the test barn at some point as well.
Are you ever heard the absolute sure rule?
Yes.
You're aware that trainers in almost every state are the absolute sure of the condition of their horse?
Yes.
I don't have any other questions.
Mr. Robertson?
Dr. Finger, have all of your opinions today been based on a reasonable degree of scientific certainty?
Absolutely.
And in your scientific opinion, with a reasonable degree of scientific certainty, can you say that the test result related to charlatan in Exhibit 8 that you talked about is not accurate?
That is correct. I don't believe that can be called at all.
Now, Mr. Freeland asked you a question, and you just said that you believe that the exposure to gamine occurred in the test farm.
Yes.
Why? What's your basis for saying that?
Because, again, the way that the lidocaine metabolism occurs is whatever the route of administration, lidocaine is rapidly transformed to its metabolites. There is only one case in which lidocaine can exceed the concentrations of its metabolites in urine, and that is if you are less than 30 minutes from exposure to collection of the urine. And the horse was only in the test barn for 45 minutes. So unequivocally, the horse was exposed to lidocaine in the test barn.
I don't have any more questions. Thank you, Dr.
Mr. Freeland?
Now, you understand the lidocaine that was found in these two horses had been metabolized, is that correct?
The threshold is 3-hydroxy. We also got a report from the laboratory, from the split laboratory, of the levels in the urine, and I can look at those lab reports and see the lidocaine levels that were present in the samples from industrial. Because what did I say earlier? They screen identifying lidocaine and megax, and then they confirm the 3-hydroxy because that's the regulated
found the metabolite of lidocaine, is that correct?
And also lidocaine.
Okay, which if you have the metabolite, it means the drug has been metabolized by the horse's body, it's gone through the horse's system, kidneys, all that, isn't that correct?
Yes, but in the case where the lidocaine exceeds the level of metabolite in urine, that exposure occurred within the last 30 minutes. So if the horse urinated at 45 minutes in the test barn, then the exposure occurred in the test barn.
Did you look at the University of California litigation packets?
I don't believe I got the package, just the report.
All right, so you can't, as you said here today, you don't know anything about the University of California litigation packets and the tests that the University of California did, is that
Only
correct?
what they reported.
You know what the results were?
I know what the results were.
Okay, that's all.
Mr. Robertson. Commission, questions?
I've got a question.
Mr. Post?
We're going to be very clear on this, what you're saying. Going on 2 days now, we've been talking about 3-hydroxylidocaine. I've never seen a test for lidocaine in the serum or urine. Where does that information come out of?
Let me get you to turn to the page.
They were constantly being shown on the screen both 3-hydroxylidocaine.
It's several places in the industrial packet. So one place, I mean, it's multiple places, but let's try 37 of 71 in
What,
the,
what exhibit number are we on?
Exhibit 8.
Exhibit 8, okay.
okay.
Just say out of 100 at the bottom somewhere.
Sorry, 43 of 100. At the top, compound submitted, lidocaine, 52 picograms per mil. This is in blood.
Page 43.
43 of 100 at the bottom.
It's gonna take me a minute to find the urine since we're specifically talking about urine here. It'll take me a minute to find that in the package.
Okay, and also another question, kind of saying, so that UC Davis, their test, they had a urine test for the 3-hydroxylidocaine. I don't remember seeing that urine test for the test, but it was very, very much higher in the urine than the serum as would be expected. But I still don't remember seeing, what you're insinuating here is much different than we've heard anything before, that the exposure was in the test mark.
I have to find it in the lab packet, it might take a minute.
Okay,
It's in here.
we got to take time for this issue. Remember seeing the test for lidocaine? Always been
It's a fun time reading these things, and I can tell you, every laboratory uses something slightly different, so my job is
I
fun.
think I can ask some questions to clarify this, or like you're looking.
Okay?
Commissioner Post, do you have any issue with Mr. Robertson maybe
No.
expediting this? And I'll certainly allow cross.
Sure. Dr. Finger, as I understand what you're saying, is that the only time that the parent lidocaine exceeds the metabolite 3-hydroxylidocaine is within 30 minutes of exposure.
Yes,
And that's what you found with regard to Gamine.
yes,
And Gamine was in the test barn for 45 minutes.
yes,
And so that is why you reached the conclusion that Gamine was exposed to lidocaine in the test barn.
yes.
Okay. Now, Gamine's litigation packet is Exhibit 9. You may be looking at,
I mean,
I just want to make sure you're looking at the right litigation packet. Charlatan is 8, Gamine is 9.
thank you. All right, so, 42,
And just one
Exhibit 9.
One additional follow-up question to what you just said.
Yes.
After that 30-minute window, then the parent lidocaine would be less than the metabolite-free hydroxychloroquine.
Correct. Okay, this is relevant because this is the preceding page, and it indicates that this is urine. Because it doesn't indicate on the page that it's urine. It indicates the page before. So I'm just showing this to show that this indicates that the next page is urine. Go ahead and go to the next page.
What are those page numbers, just for the record?
On the one that says bottom 42 out of 95.
Of Exhibit 9.
42 of Exhibit 9, thank you.
Okay, now, these are the actual chromatograms of the screening. So on the far left of the top row, it's circled. It says 3 hydroxy, so we know it's urine because the page before it indicates that this page is urine. And so there you go, 3-hydroxylidocaine, concentration 0.683. So that's the peak at the correct retention time, and then it 1.31. They're arbitrary units, but it's basically the shaded. It's the area of the shaded area of the curve, and then go over 3, 2. There you go. Lidocaine. That's the parent. Concentration 2.8 nanograms per ml. So that's 2.8, and compare that to 0.683. So yeah, compare that to the 0.683 of the 3-hydroxy. So the lidocaine exceeds the concentration of 3-hydroxylidocaine.
And what would be, is Commissioner Post still? Again, what would be the timeline when they would be about equal?
It's, so the only study that's looked at this is a SOMA study published in 2011. And the first time frame that they collect the samples is half an hour. And at a half an hour, it's already, the hydroxylidocaine already exceeds the lidocaine. But what you can see is the curve going rapidly down. So the curve is going down. So it's sometime before 30 minutes that the lidocaine exceeds the 3-hydroxylidocaine.
Minutes or less?
30 minutes or less. So there's no chance this horse had lidocaine in her system at the time of the race.
In your opinion?
In my opinion. Based on the scientific literature and my own studies with the related compounds with lidocaine.
Any further questions from the commission?
Everyone.
Sure.
Alex Lieberman, what was your position when you were in Kentucky?
When I worked for the Kentucky Horse Racing Commission, I was a state veterinarian.
You know, what gets me is that I get everybody coming up saying, this doesn't matter, this shouldn't be here. Does anybody take to these governing bodies and say this is baloney?
I do this 5 times a year. I go to every ARCI meeting, and we get.
And I'm meaning that respectfully.
No, and I mean it. My response is just honest as the day is long. I don't understand it. I totally do not understand it, because you go in there and you lay it out, and they look right at you and say, well, these levels are working. We don't get that many positives. Well, that's all fine and good, except for when the one guy that's positive is innocent. Then that's a problem. And I do this. I just did it earlier in the week. We had 2 ARCI, and I don't get paid for that. We had 2 ARCI meetings last week, trying to explain that this is why we do this, the studies. This particular substance is just, this is embarrassing. A 2B penalty is absolutely appropriate if somebody blocked a horse before the race. But this kind of thing, and then when you have all of these, the levels, the standards to which we hold trainers, where you have to be absolutely certain. We've swabbed stalls We swapped stalls in West Virginia and found lidocaine in the stalls, just walking into a receiving barn stall and swabbing it. We got lidocaine. We did a stall at
Let me ask you
Kinley.
something.
That's another zone.
Without interrupting that, it
I'm
was
sorry.
too bad. And like I say, I appreciate your effort. I just get over and over again how this has no effect, but it's still in the rules. And this rule, it's kind of like having a stop sign where it doesn't make any sense. You go through a stop sign, the cop sees you, you're gonna get a ticket. That's basically where we're at.
It is, but it goes to the mitigating circumstances, that you can mitigate this all the way down to a fine. I mean, that is your prerogative. And as of right now, they just had, in one of the meetings last week that we were in, where they discussed making any drug positive an automatic disqualification. And that was remanded back to their scientific advisory committee for further evaluation. Point being is that the commissioners weren't ready to do that at ARCI. And this is why. It's because 2B is absolutely appropriate, but not in the case of environmental contamination.
Commissioner Hunter, I have a question. So we heard from from a representative from Industrial and from Cal Davis. Can you think of a reason, did they not look at the same study? Is there knowledge of the information not at your level? What's your explanation of it? And I guess I'm asking you to.
Am I allowed to answer that? Yes.
Sure. I mean, as far as I'm concerned.
They're analysts. They're chemists. That's their qualifications. I'm a pharmacologist and a veterinary internist.
So are you saying they don't understand the pharmacology, or it's not their job to interpret it in the way that you're interpreting?
Correct.
Which one of those?
Oh, both.
Thank you.
Commissioners, any further questions? Mr. Robertson, I suppose, is their question your
Just real briefly, I just want to make sure. So, Dr. Finger, what you're saying is that when the parent lidocaine exceeds the metabolite, 3-hydroxylidocaine, when that scenario appears, that the exposure has to have been within 30 minutes.
Correct.
Thank you.
Mr. Freeland?
Excuse, the half-life on lidocaine is very, very short.
Correct. The parent lidocaine, yes.
Yeah. Okay. And that's not been brought up before, right, that I've heard to this point. And I missed something.
Commissioner Post, what if there was a secondary exposure to lidocaine, say, before the race and after the race?
I wouldn't be able to differentiate those in this case.
It could produce that result, though, couldn't it?
I mean, it's just,
We need the record to reflect she was nodding her head or she's.
Yeah, that's correct, I'm sorry. Would you just audibly answer that question?
I said sure. I said yes.
Okay. We couldn't hear it if you said it. so.
Sorry.
and that was on
She
Dominion.
got the answer.
This Alex Lee, that was on Dominion.
That's correct. But you similarly can't say that that it did not get a single exposure afterwards. You can't differentiate those.
Are you saying, what about Charlotte? Was that at the test barn or before the test barn?
Based on the levels, it would have been before, assuming that you can count on the levels, which I'm saying you can't, because they don't meet the minimum standards, which incidentally, your analyst experts ought to know that.
Who's analysts?
Well, he had made the comment about why did the other two experts not bring this up, because this is not their area of expertise, the pharmacology. But they should be aware that you can't call a positive if it's less than 3 to 1, the ratio of the ions.
Okay, Commissioner Hunter, again, so you're saying you said Truesdale should not have called it positive, but you're saying the same for for UC Davis?
Well, so Davis didn't call a positive, right? They just confirmed. So they're not, the two things are not the same.
Okay,
Calling a primary positive
Sure.
and
Right.
confirming a split are not the same.
right, but they confirmed the positive result.
They indicated that the sample they received was positive. Because the analyte is a metabolite and not parent compound, the actual quantitation that comes from Davis is gonna be up in the air as to what that means. And the reason is because there's going to be literally a change in the tube, because there's still living, breathing cells in the tube. There could be a change from the time it's taken to the time that it's run. We're looking at a metabolite. A metabolite is what the positive is. So all they can really do is say that yes, it was in the sample, but they really can't tell you how much. Because it's, in theory, the lidocaine, any lidocaine present in the sample could continue to be metabolized so that your 3-hydroxylidocaine would go up. So it would be of questionable value, I'll put it that way, to really rely on the levels that were called by Davis.
I have a question. Ms.
Which
Bushra.
race?
So you're saying the one horse, you feel like it was lidocaine was detected in the test barn?
Yes.
Okay. If that were true, then when the other winners of other races, horses tested positive with the lidocaine?
Well, if the exposure was to somebody else in the test barn and not the person that we know had a lidocaine patch, you might expect that, but the issue being is that if a horse tests below the screening limit, but has lidocaine, in other words, if it's right below the screening limit, and then again, lidocaine is a strange substance because they're not even screening for 3-hydroxylidocaine, right? They're screening for lidocaine and MEG-X. So you'd actually be amazingly less likely to catch somebody who's intentionally blocking a horse.
Right.
Because what did I tell you? It all turns into 3-hydroxy pretty fast. You'd actually be less likely to catch that guy than you are to catch somebody with this low level of environmental contamination.
So in your opinion, why did the third horse that Mr. Backer had, how come it didn't test with the lidocaine?
You know, again, if you have some on your hands, I mean, obviously, again, assuming that these levels are correct, which I don't think you can, for charlatan, it's not confirmable. But on the other horse, assuming that these levels are actually correct, then obviously one horse got exposed to more than the other horse did. And then the third horse got exposed to even less than the other two. And so that it's a threshold substance. And chances are extremely good, because I get asked that question at these RCI meetings all the time. It's like, well, if environmental contamination is a thing, we'd be having these all the time. You are. 90% of all positive tests are some form of environmental contamination, be it some weed that grows in the hay or some substance in the case of, you know, when we do these stall screens and we're testing stalls and finding stuff in the stall. I mean, that's a regular thing.
And maybe you could help me out, Mr. Becker. And it's been too long for me, which horse, like when did Nadal run? Which order did the horses run?
Charlatan ran first.
Do what?
Charlatan ran first.
And then Gamine first?
I think it was Gamine, Charlatan, Nadal.
Okay.
Commissioner Post, you never did touch on the urine test at UC Davis. Can you describe what kind of test that was? Was it also mass spectrometry screening?
It would have been confirmation, and again, the difference between a split test and a primary test, there's many differences, but among the differences are the secondary, the split test, what they do is they send out to all the laboratories, we have a substance positive at this level, can you run that? And the lab has the option to say, we can't do that because that's too low for our abilities, and so we can't do that. So the point being is that actually happens. Laboratories can't run splits because we're testing at such a low level. Most of these positives are really close to the level at which maybe we can identify it, maybe we can't. When you're sending a split test off, instead of having to go through that, what did I say, the rigmarole of the screening, you're not screening for 3-hydroxy, but you're screening for other things, and then you're confirming the 3-hydroxy. For the split laboratory, they're instructed, this is what's in there, and this is the level. So they can turn up all the dials and make sure that they can identify the substance that you're looking for, because they already know what they're looking for. This is not a blind sample, they're not doing a primary screen. A positive certificate means we screened, we found it to be suspect in screening, and then we dialed up all the tests to make sure that we could confirm, and we confirmed. If you fail the screening and confirmation, then bingo, you get a positive. The secondary laboratory skips all those steps and goes straight to the confirmation. And so that's why one of the reasons why the split test cannot be used as a primary test. It didn't go through the screening process. Had it missed that and not been identified in the screening, it would have never been identified as a positive. Why does that matter? If it was actually there, it matters because there also might be a dozen other horses that would have been there had you said, specifically look for this substance and go through all of the special steps and preparations that are required to identify this substance.
This graph we're looking at showing the level of lidocaine.
Yes.
Looks like it's from industrial. Do we have one from UC Davis?
We never got the full litigation pack, or at least I didn't see it if we did.
So
So
the
all I
only-
have is the results.
The only test we know of for lidocaine is industrial, and what you're saying is it's less than 3 times the background, and therefore.
Going back, the less than 3 times the background is so we're talking, the lidocaine sample, that's convenient. The less than 3 times background where the confirmatory test should never have been called is Charlotte. Because the requirements for calling a positive on a mass spec test is, like I said, the most liberal one is 3 times background, which it fails to meet that criteria.
Does RMTC not use that same standard?
I have not seen an RMTC document, but that's a general mass spec standard, and most of them will actually go to 10 times background. So, but the studies that I do, we don't quantitate unless it's more than 10 times background.
When you say you do for who?
I'm a pharmacologist, so the pharmacology studies that I conduct.
But again, I have to keep beating this. We don't have a secondary test for lidocaine from UC Davis.
Davis reported a lidocaine, but as I mentioned, over time, and of course we're talking urine, it's urine, not blood, where the lidocaine exceeds, because it's only in urine at a higher concentration, it's extremely close to when it was administered. So, we do have those results from Davis, and they're inverted, but not by very much, meaning there's a little bit more of the metabolite than there is lidocaine in the urine. But again, over time, you can't rely on those absolute numbers because the samples have sat around longer and their metabolism continues to occur. In urine, it uses bacteria because it's free pass urine. So there's bacteria in it. So over time, especially when like some substances, and I'll use dexamethasone as an example, some substances go in one way, they come out one way, the threshold is they're exactly the same. The threshold is dexamethasone, exactly the same thing that goes in, it's exactly the same thing that comes out. Nothing happens to it while it's in the animal. These substances that get metabolized, the longer you wait, the less meaningful the quantification is. Because it'll change even in the tube or in the cup.
Do you think UC Davis would disagree or agree with you?
I mean, don't disagree with me, but, well, I mean, not on, well, I'm just saying, they're paid to defend their work, so.
I understand. Are you paid to defend yours?
I'm paid to just tell you the way it is. It's not.
You think Davis is not paid to do the same?
No comment.
Okay. Okay,
Commissioners, anything further?
no, sir.
Let's go back to Mr. Robertson.
I'd like to,
Can I ask a question? Is that okay, Byron? This is about background and a gas chromatograph, okay?
It's Elsie, look at
Elsie, okay. If the background is at 5 and you get a recording of 25, then you can say that's a positive because it's more than 3 times 5.
Absolutely.
If the background is 15 and you get a report at 25, you can't say that's a positive because it's not more than 3 times 15.
Correct.
And that's because there is a variation, a standard deviation that can occur just based on background, and it has to be sufficiently above background before a scientist can say, now we got a positive.
That's correct.
And so with charlatan, you didn't get 3 times higher than background for the finding, and so a scientist can't look at that like you and say, I can say that's a positive because it's too close to the background.
Correct. And the reason I'm so up on that is because we did these MIPIM studies, and we had to tear our hair out trying to get the levels down to where we needed it to be in order to make recommendations.
And in some standards, it has to be 5 times higher, and in some others, it has to be 10 times higher for you to say, now I got a positive.
And in our studies, we use 10 times.
Anything further, Mr. Quattlebaum?
No, thank you.
Thanks for
I just want to make one thing clear, and I think it is clear in the record. You did not receive a copy of the University of California Davis litigation packets on either horse, is that correct?
Correct.
And so you have been espousing how the University of California did it without ever reading what the University of California did in the litigation packet, is that correct?
I believe in the report that we did get, it said by Mascotron.
Okay,
And that is the standard method used by every lab, and they're RMTC and ISO 17025 accredited to ILAC standards, which would mean by, it'd be incompetence if they didn't use that
well,
standard.
the point is you have not read the University of California litigation packets on either horse, is that correct?
Correct.
Okay.
Anything further?
And so you explained the different approach to testing that occurs with a split sample compared to a primary sample.
Yes.
And is that different approach why in science you don't rely on a split sample when there's a problem with the primary?
That would be the scientific reasons, yes, absolutely.
Thank you.
Mr. Freeland?
No questions.
And we,
Commission?
excuse me a second.
Sure.
UCA Davis called it a positive, is that correct?
Yes.
Thank you.
Anything further from any of the attorneys or the commission for this witness?
No.
In that event, thank you, Dr. Finger.
Very much.
thank you, Dr.
Thank you.
Mr. Robertson, does that end your
That is the end of
witnesses?
my witnesses.
Council, are we ready to proceed with closings, or would you like to take a short break?
I'd like to go to the restroom.
Yes. Let's,
See some nods up there.
I've got, you want to do 12:45? That's about 10, we can do longer. I'm at y'all's pleasure.
I think we need to take it shorter.
Sure, because you've got a, sure. Let's do 5 minutes. How about as soon as we can? Back on the record, closing arguments. Mr. Freeland, I'll turn it over to you for a closing.
I'll make this very brief. The commission has heard the evidence now, and the job of the commission is to see if there's sufficient evidence to sustain the Stewart's rulings, or you can modify the Stewart's rulings, or you can totally dismiss the Stewart's rulings. In other words, you can say, I agree with them, I disagree with them, and we want to change it. So you have that option. It's based on the evidence that you heard, whether there's sufficient evidence to sustain the rulings, and you make up your mind as commissioners based on your experience. You have the duty under the statute to protect the interest of the public, the horsemen, and the owners, everybody. So you have the obligation to protect everyone's interest in the state of Arkansas's interest, and you can change this ruling, you can sustain the ruling or whatever based on sufficient evidence that you find in this case. And I want to try to make this brief because you've heard so much, but I've just been amazed in this case. Exhibit number 4 is the term of the contract, and it says right in the term of the contract, if you look at Exhibit 4, which is the commission's exhibits, the last page of the term of the contract says assignment. This contract is not assignable, or the duties that are delegatable by either party without the written consent of the other party to the contract. Well, delegatable means that you have the other party do the duties. They perform the function, the testing function. That's what you mean by delegating something. Assignable, you assign the whole contract. With the written consent of the other party. When Dr. Locate, the state debt, sent that letter back saying, this is what we want you to do, that was the written consent of the Arkansas Racing Commission. And you remember the letter of May 25th, where it says, this is what we'll do. We'll test everything to March 17, 2020, and everything after that we send out to industrial. Well, the written consent was when the email was sent back, and that email, I believe, is number 7. It is exhibit number 7. It says, please send our samples from Oakland and Southland to industrial labs for testing. I discussed this with Smokey Campbell. This is his decision. If there are any problems, please call me. That's from Joseph Locane. The veterinarian for the Arkansas Racing Commission was giving written consent to assign these contracts. The other, the other place that clause is in there, the invitation for bid, the pages aren't numbered, but it's under the standard terms and conditions, section 4, assignment again says any contract entered into pursuant to this solicitation shall not be assignable nor the duties delegatable if by either party without the written consent of the other party to the contract. So it's exactly the same clause in the contract and in the invitation to bid. And that is about as clear as you can make it, that you can assign these contracts as long as there's written consent. And also, I'm telling you that Arkansas law is that the parties to a contract can assign those contracts. They have that right. We have law clerks that work in our office, had extensive research done on this. That is the law of the state of Arkansas, that these contracts are assignable, and they're assignable by their actual written terms. There's no question about that. Now, the complainant said there were seven reasons to dismiss this case. The broken chain of custody. Well, all the broken chain of custody they talked about had been the Truesdale chain of custody. And the chain of custody they're talking about is someone opened the ice chest. There is no testimony, no evidence before you that any bottle of urine or any vial of blood was ever disturbed in any way. And you saw the demonstration, those were sealed with a red tape over them, over the blood and the urine, and the number is written on there. Those arrived at the Truesdale lab intact. There's no disputing that. And then what's even more remarkable is the University of California, Davis they received a split sample directly shipped from Oaklawn, and there's not even been an attack about the chain of custody on the University of California Davis test. The confirmation tests were done, no one has even attacked those chain of custodies. It went directly from the Arkansas Racing Commission veterinarian's office to University of California Davis, and they confirmed the lidocaine presence. Somehow, the complainant's saying you can't use the split sample test. Well, Mr. Bafford chose the lab and sent it off under the Arkansas rules. Your duty is to look at the Arkansas rules. There is no rule saying that you can't consider the University of California Davis split sample test. And I challenge the complainants to cite you any law, any case law, any regulation that says you can't consider the University of California Davis. You can and you should. There is no question about it. Okay, the seven reasons that they said there was a broken chain of custody. All they've done is criticize the Truesdale handling, but Truesdale did common sense. They opened the box up to see what was in it, cataloged it, inventoried it, sent it on to industrial. And you heard the industrial lab testify, said it tested positive for lidocaine. Those samples, the chain of custody is the sample. That's the most important part. It's not the box it came in. Like when you get something for Christmas, it's not the box it came in, it's the present inside. They're saying another reason, the second reason was the Truesdale letter was signed by Julie Hagahara. Julie Hagahara was the one who was designated by the commission at the beginning of the year to be the chemist for Truesdale. And she continued to do that because they subcontracted it. When Smokey sent that when they sent that letter out, they subcontracted it, which made Truesdale still responsible as the prime contractor. So it was correct coming from Julie Hagahara also. And they're saying that Truesdale, and this is the third reason, Truesdale initially cleared both samples. They did, but they cleared that up within a few hours or a few days. And there's no proof, no evidence that caused any harm or changed the analysis of this sample. The fact that they initially cleared it, that was a mistake that was made by Truesdale, but there's no evidence that changed the analysis of those samples, and that analysis wasn't correct. The fourth reason they're saying it was an unlawful subcontractor, not allowed for. And then, I mean, I've gone over that. It's right in the documents. We read it a minute ago. That is an amazing argument to me that someone would make that with a straight face. They said they're improper positive findings by, because they weren't supervised properly. Well, I say that's false. Both labs that looked at it found these were positive for lidocaine or the metabolite of lidocaine. Then they said the breach of confidentiality. That we have a confidentiality rule, but if the rule of confidentiality is breached, that's for the Racing Commission to handle against the party that breached the confidentiality and take disciplinary action if you think it's appropriate. Mr. Bafford testified and he never once mentioned any harm that came to him because of a breach of confidentiality. You didn't have a breach of confidentiality that affected the outcome of this case, and there is none. So the proper remedy for any breach of confidentiality that occurred, which they didn't prove, would be, like with Bernie Heddle or anyone else, to make Mr. Heddle come in before the commission and say, what did you say, and determine that was a violation of the rule, and you could discipline him if you so chose. And the seventh reason they gave that there was no rational or scientific basis for the rule. Well, we had Mrs. Scolay, or Dr. Scolay testified they did a 6-horse study at the University of Iowa, and that was accepted by her agency when they made the recommendation for the rule. The RMTC accepted that. That was a scientific study. They argue with the scientific study and say it was not adequate, but there was a scientific study. And this same argument has been taken to court in Kentucky by Mr. Robertson, and he lost. The court in Kentucky said that you do not have to have the scientific basis, because that put all of you in the position had to determine there's a scientific basis. You adopted the RCI rules, which contained the 20 picogram threshold. That's all that's necessary. But then on top of that, we presented Mary Scolay, who said there was in fact a scientific basis for this 20 picograms. So this is I mean, every case we have like this, when we have a trainer come in, nobody knows how it got there. Everybody knows Mr. Baffert's an honest person. He's well liked by everyone here at Oakland and elsewhere. But this is the same thing you hear in every single case. They don't know where it came from. They try to attack the chain of custody and try to throw whatever they can against the wall and see what'll stick. And that's exactly what's happened in this case. But the facts that can't be ignored are this contract was assignable. It was assigned. Truesdale and then through industrial found that it was positive for lidocaine. Mr. Baffert chose the referee lab. We sent it to the referee lab. They confirmed it was positive for lidocaine. There was no getting around that, and no one has criticized what University of California, Davis did. In fact, the last witness hadn't even read the litigation packages. She hadn't even read those. So there's no rule or logical reason that you can give why the commission can't listen to the referee lab in this case and consider that. That is not the law. It is not a rule. You can consider whatever you consider to be sufficient evidence based on your experience as racing commissioners. And so you need to, when we're finished with the opening statements, have a deliberation and then make a ruling whether you sustain the Stewart's ruling, change the Stewart's ruling, whatever you want to do, and then we will draft findings of fact and conclusions of law, which we would have to send out. This would take some time, and those would have to be signed off on at a later date by the entire commission. I think that this is a really simple case, very straightforward. Like this happens in every case. You try to make a big deal out of some of these little facts that don't make any difference and create a storm, throw something against the wall and hope it sticks. Keep your eye on the ball. The two test labs did it. They tested positive for lidocaine on both of them. There's nobody who has attacked University of California, Davis, and there's no reason not to use that. So it'll be your time to deliberate if you've heard from the other side. Thank you.
Thank you, Mr. Freeland. Mr. Robertson, are you handling the closing?
Yes, thank you. Commissioners, I want to begin first by thanking you for your time and for your attention. I know these cases can get tedious and long at times, but you all have been fully engaged and focused on doing your job, and it's greatly appreciated. When we started this case, I told you that there were going to be 7 independent reasons why the matter should be dismissed. And I told you that each one of those reasons, standing alone, merited dismissal, but collectively, they were overwhelming. I want to review what the facts and the evidence has been in this case on those issues. First, chain of custody. Every single witness who has testified today, including all of the ones that Mr. Freeland called, said chain of custody is not just important, it's vitally important. And every single witness said that you have to have an unbroken chain of custody. And we have 2 problems here with the chain of custody. One, we had samples that started in 2 coolers with 2 numbers on them, and that's what left Oaklawn Park. And what arrives at the testing lab are 3 coolers with 3 totally different numbers on them. That's problem number 1. Julie Hagahara of Truesdale Laboratory says, well, I opened them, I took out those samples, which every witness has said the cooler should never be opened until it gets to the testing lab, so that was wrong. I took those samples out, I added other samples from other jurisdictions, put them into the 3 coolers and ship that to industrial. And she acknowledges, and everybody acknowledges, that there needs to be chain of custody documentation, a form that says, these are the 3 coolers I shipped from industrial, or excuse me, from Truesdale, with these numbers, so that when industrial gets those coolers, they can check and make sure that what they've received is what left Truesdale. And Julie Hagahar herself said that documentation should exist, and it doesn't exist. Now, what's the big deal, right? This is just a technicality, where you're just throwing something on the wall. Here's why it is a big deal, and here's why it's not a technicality. Without an unbroken chain of custody, you cannot rely on the test results. We don't know what happened to those coolers from Truesdale to industrial, because we have no chain of custody documentation to prove that what arrived at industrial was what left Truesdale. It's the fundamental building block upon which all test results must rest. And without that, test results are just not reliable, and you can't punish somebody for that. Now, you may say, well, isn't that far-fetched? Isn't it far-fetched that something happened to the coolers between Truesdale and industrial? Well, is it in today's world? Is it? I don't know. I mean, when you're a high-profile trainer like Bob Baffert, I can assure you there are people out there, when you're at the top of your game, they want to bring you down. All right? And it's a big race like the Arkansas Derby. Is it that far-fetched? But here's the important thing. Whether it's far-fetched or not, what matters is that an unbroken chain of custody is the golden rule. It's the golden rule for relying on the validity of test results. Everybody has said that and testified to that. And don't just take my word for it. Don't take my word for it. You don't even have to take the word of the chain of custody expert, Mr. Schultz, that testified that. You don't have to take his word for it either. Take the word for it of the stewards for the Arkansas Racing Commission and what they did with the Steve Hobby case. The Steve Hobby case they dismissed because of chain of custody issues. That's what they said. And the chain of custody issue in that, there was no evidence that the urine or the blood samples in the Steve Hobby case in that cooler had been tampered with or adulterated. They were intact, just like they're saying, well, Mr. Baffert's samples were intact. Same thing in Steve Hobby case. There was no evidence in the Steve Hobby case that the cooler was ever opened. Mr. Kettle said it was never opened, everything was intact. There was just some evidence of some unspecified damage to the outside of the cooler. And they dismissed it. The chain of custody issues in this case are significantly greater than what was in the Steve Hobby case. But the stewards, they know that it's the golden rule. You have to have an unbroken chain of custody. And so they said, because of that, we're dismissing this case against Mr. Hobby. I told you at the beginning, I wasn't going to ask you to treat Mr. Baffert any better than anybody else, any other trainer. But I did say I was going to ask you not to treat him any worse. And if the Steve Hobby case gets dismissed under those circumstances, this case should clearly get dismissed. Well, but Mr. Robertson, we've got a split sample. So, you know, none of that really matters. We can just, you know, the split sample came back. Doesn't that make everything okay? The answer to that question is a resounding no. because you don't even get to the split sample unless you have a valid and verifiable primary sample finding. And it's like the fruits of a poisonous tree. You can't get to the split when there's a broken chain of custody in the primary. Again, but don't take my word for it. And Mr. Freeland said repeatedly, well, Mr. Robertson hasn't presented any case law. We're not here to present you all with case law, but I would submit that Mr. Freeland has no case law he can present that says, oh, you can use a split sample when there's chain of custody problems with the crime. But again, don't take my word for it. Take every single witness who testified, including all of the witnesses that Mr. Freeland called, from Truesdale, from Industrial, from UC Davis. I asked every single one of them, have you ever seen a situation where a racing commission had a problem with the chain of custody and the primary sample, but they just relied on the split? And they all said, never seen it. Never seen it happen before. And again, you know what the best evidence of this is? The Steve Hobby case. The Steve Hobby case had a split sample that came back positive, 2. And the stewards in that case didn't say, well, we have a chain of custody issue with the primary sample, but we'll just rely on the split, Mr. Hobby, and we're going to punish you for that because the split came back positive. They didn't do that because they know they can't do that, and they know that that's not right. Again, I'm not asking you to treat Mr. Baffert better than any other trainer. Just don't treat him worse. That's fundamental fairness. Second, the issue of Charlatan being labeled as a guilty, and you've heard the testimony on that. And what Truesdale says is, well, we made a mistake. Okay, we made an error. We acknowledge that. That's not an acceptable mistake, number one, if that's in fact the case. But is it possible? Is it possible that when Julie Hagahara opened those coolers, took those samples out, added additional samples from other racing jurisdictions, and added their own specific number from Truesdale Laboratories, is it possible that there was a mix-up there and we didn't end up with the right sample? And no one has explained, if you get past all of that, why Charlatan's sample wasn't called, if it really came from Charlatan, as being high in testosterone. The only explanation we got was, again, way after the fact, Ms. Hartman saying, oh, well, we made a mistake. We made an error with that. But there's no documentation to prove that, to establish that. She just threw that in at the end of her testimony. And how many mistakes and errors are we going to allow before we say, you know, it's not fair to punish this man under these circumstances. It's not fair to do this. That's not what we've done with other trainers. We're not going to single Bob Baffert out and punish him. Number 3, the fact that Charlatan's sample was initially cleared. Julie Hagahara acknowledged that. You've seen the report, sample cleared. And she says, well, there's another mistake. We made another mistake there. She offered no explanation, 0 explanation for how or why that mistake was made. Is it possible that someone at the lab, like Dr. Finger, looked at that and said, this can't be called a positive, so we clear it, and then someone changes their mind? I mean, you talk about amazing to me It's amazing to me that this race is run on May 2nd, 2020. And on May 15th, 2020, 13 days later, after all the testing, Truesdale comes back and says, clear. So here's what we've got. Admitted errors by Truesdale Laboratories. We don't have chain of custody. That documentation should exist, and we don't have it. We made a mistake. We called charlatan a gelding. He's really a colt. We made a mistake. We cleared charlatan samples initially, 13 days after the race, and reported that. We made a mistake. Again, at what point do you say, there's too much here? There are too many mistakes for us to impose the punitive measures on this man of disqualifying the horse and suspending him from practicing in his chosen profession. I mean, I started thinking about that. You got a license to practice law. I can't imagine Kentucky Bar Association came to me and said, we're going to initiate some proceeding to suspend your license to be able to practice law. I don't know if any of y'all have to have licenses to do your professions. That's a big deal. That is a big deal to tell someone, I'm going to take your license away or suspend it. And you should proceed very cautiously and carefully before you do that. And I submit to you that given all of these facts and circumstances, which you need to consider, and whether you want to consider them to dismiss, as I say, or just as mitigating circumstances, there's just too much here to say, we're going to punish this man for this. We're going to suspend his license. We're going to disqualify his horse. Now, fourth, the contract. And this is amazing to me. Okay? Every single witness who testified, every single one, said this was a subcontract. Nobody said it was an assignment. There's a difference between a subcontract and an assignment. Every single witness testified this was a subcontract. And every single witness also testified that, or excuse me, not only did all the witnesses testify to that, but that's what all the documents said too. Every document that you saw in front of you that was put on the screen, they all said subcontract. They didn't say assignment. This wasn't an assignment. It was a subcontract. It was an unlawful subcontract. It wasn't allowed under both the contract between the Arkansas Racing Commission and Truesdale. It wasn't allowed under Arkansas law. And now this is an after the fact of, well, let's try to fix this and call it an assignment, when it's not. Number 5, the positive reports signed by Julie Hagahara. Every single witness again said, you can't do that. She can't sign those reports. She's with an unaccredited lab, and she didn't perform the testing or supervise the performance of the testing. And that's not allowable. And that's a big deal. That's how this testing works. And that's how these testing laboratories are supposed to operate under all of these rules and these guidelines. And we can't just continue to have mistake after mistake after mistake after violation and say, it's no big deal. They're just throwing stuff on the wall. This doesn't matter. We're going to punish this guy anyway. And lastly, the breach of confidentiality. It's not lastly, it's second to last. The breach of confidentiality. I'm not going to go into that. Mr. Heddle acknowledged confidentiality was breached. Okay? I think it's obvious that caused prejudice to Mr. Baffert. He's got to, anything that comes out about Bob Baffert, he's got to answer 1,000 questions in the press and from the media. Everyone has testified. One of the reasons for confidentiality is so that he doesn't have to do that. So the cases aren't tried in the court of public opinion. And Mr. Heddle himself doesn't feel pressure, now that all this is out, to punish Bob Baffert. Last, the regulation at issue in this case, okay? 20 picograms of lighting. Here's what I'll say to you about this. Not every single witness who testified said at these levels in both Charlatan and Gamine, there would be no pharmacology in a horse. Every single witness. They had plenty of opportunity to find a witness who would come in here and say, no, it did have some pharmacology. It did have some effect on the race. You didn't hear that testimony because it doesn't exist. And you did hear a very compelling testimony of Dr. Finger, who I believe was the most compelling witness in this whole proceeding, saying 840 picograms. Above that, there's pharmacology. Below that, there's not. Okay? So this didn't affect the outcome of the race in any way, shape, or form. Okay? And you can consider that, and you should consider that as a mitigating circumstance. This is not a situation where it's a stop sign and it's black and white. These rules are in place, and they say that if there is a finding above the threshold, even if you want to argue the threshold's okay, then we start this process. And we start this process to try to figure out, well, how did this happen? And are there mitigating circumstances in terms of, was this intentional? Was it accidental? Was there contamination? Did it have an effect on the horses? Could it have altered the outcome of the race? That's when you consider all of those things. And so it's not black and white stop sign. That's why the rules say, consider, you should consider mitigating circumstances. And I'll say this. I think Dr. Finger's testimony about contamination in the test barn was very compelling. Very compelling. And if you believe that Gamine could have been contaminated in the test barn, that's not Mr. Baffert's responsibility. And I believe that's highly likely, given that we had another horse, Basin, in the race who also tested positive for lidocaine. Now, I'm just going to conclude by saying this. I think I must finish by how I started. I think this case should be dismissed. There are simply too many errors and mistakes that strike at fundamental fairness and reliability and validity of test results, and fundamental fairness of whether we're going to punish a man under all of these circumstances. And again, you should proceed cautiously. You've got great power, and you should exercise that power to implement punitive measures very judiciously. And the Arkansas Racing Commission should not say, Mr. Trainer, we're going to hold you to this exact standard. You are the absolute insurer of the horse. No excuse. But if our testing lab breaks the chain of custody, mislabels a horse as a gelding, makes a mistake and clears your samples, and all of these other mistakes are made, if that happens on our end, that's too bad. Not a big deal. It is a big deal. And that's not the message that you want to be sending to all of the many horsemen and owners that come here. And that's not fair, and it's not just. And so, in conclusion, again, I believe dismiss. I firmly believe that. But if you don't want to dismiss, given all of these circumstances, you surely should consider mitigating circumstances. Okay? And when the errors and mistakes go up here, the need to consider mitigating circumstances also go up. And so, if you don't want to dismiss, at a bare minimum, considering all of the circumstances, you should mitigate and not disqualify or suspend Mr. Knight. I really appreciate your time and your professionalism, and thank you for the opportunity to be here.
Thank you, Mr. Robertson. Mr. Allen?
Thank you. Gentlemen, also want to thank you for your time and your patience over the last day and a half, coming on 2 days. It's greatly appreciated. Again, Justin Allen, I represent the ownership interests of Charlotte, and I will be brief as I have been the last 2 days. And what I want to do is put a finer point, if I may, on this mitigating circumstances issue. Because if you do indeed come to the conclusion that you have before you valid test results, from whatever laboratory, that showed these 2 horses had lidocaine in their system in excess of the threshold, and the chairman's talked about this a lot, you're not required to disqualify and unplace that horse and make them forfeit their purse. You're not required to suspend the trainer. You have options because you are allowed to consider mitigating circumstances. So what do we know? And I'm going to talk to you a little bit about your rules. There's no question, this comes from the Arkansas Racing Commission rules. Lidocaine is a Class II substance. It carries with it a Class B recommended penalty. What are those recommendations? Well, for the trainer, it's a 15-day suspension, absent mitigating circumstances. A $500 penalty, absent mitigating circumstances. For the owner, it's a disqualification and loss of purse, absent mitigating circumstances. Those are from your rules. Rule 1217J is titled Environmental Contaminants and Substances of Human Use. And I'm going to read from it. Substances of human use and addiction may be found in the horse due to its close association with humans. If the preponderance of the evidence presented in the hearing shows that a positive test is the result of environmental contamination, including inadvertent exposure due to human drug use or dietary intake or is indigenous to the horse, those factors should be considered in mitigation of any disciplinary action. 1217J of y'all's rules. We also know from Exhibit 24 and Dr. Locank's memo to the Commission in 27, there's a history of the Commission considering mitigating circumstances and imposing something less than the recommended penalty, which is what he asked the Commission to do in 2017. He talked about there being a technical mistake, not an intentional violation of the rules. In his opinion, it had no impact on the outcome of the race. And he pointed out that in 2017, of that year, there were 5 drug overages or positives. 4 of the 5 carried a Class B penalty. Same thing here. The stewards gave 3 of the trainers involved only warnings. There was no loss of purse, fine, or suspensions. Y'all can do that here. It's up to you. But y'all can do that here. Just like the Commission did in 2017, where the gentleman who was taking the cough medicine made the bad decision of urinating in the stall, and that, of course, tested positive above the threshold. The Commission, I submit to you, considered mitigating circumstances there and chose not to disqualify the horse or have it forfeit its purse. Now, the reality is, based on all the testimony, I think most of us has some question as to exactly when and how the lidocaine got into these 2 horses. Now, I suspect some, if not all of you, are probably leaning towards the greatest likelihood is Jimmy Barnes in his use of the tonic pain patch. But what we do know, I think, is whether it's that or the test farm or some other source, it was human contamination, inadvertent human contamination. I think we can all probably agree that is what happened here. We just don't know who the human was, when and how, but they made a mistake, they made an accident. It was an accident. We also know that the testimony is undisputed that these levels of lidocaine and these two horses would have no impact on the outcome of the race. Because I could see you saying, well, Justin, I hear what you're saying. It was an accident, they made a mistake, but we've got to protect the integrity of horse racing. And even if it was an innocent mistake, we can't allow those to result in a different outcome of the race. That's not the case here. Y'all saw the race, you remember it, you've heard the testimony. That's a mitigating circumstance you should consider, is that there was no impact on the outcome of the race. You've heard, I've asked you to assume that you've got valid test results, but you've heard all the discussion. I'm not going to get back into it from these gentlemen behind me and from the witnesses about all the various problems with chain of custody, cleared results, subcontract versus assignment, etc. Those also should go to mitigating circumstances. Again, even if you find that despite that we have valid test results, I think you should throw that on what I'll call the mitigating circumstances pile of, yeah, we probably should deviate from the recommended penalty and do something less than that. You should consider that, I submit to you. And what we do know is we have absolutely no evidence whatsoever of any intentional administration of lidocaine to either of these horses. Somebody made a mistake, and we've heard about a lot of mistakes here on both sides, and we're all human, we all make mistakes. But somebody made a mistake that resulted in the presence of the lidocaine in these two horses, but I don't think it was a circumstance such that you should impose the recommended Class D penalties, but rather you should exercise your discretion as you're authorized under your own rules to mitigate that and not disqualify this horse and forfeit the winnings or penalize Bob Baffertt. Again, thank y'all for your time.
Thank you, Mr. Allen. Mr. Freeland, anything further?
Very, very briefly,
Rebuttal, we're going to do rebuttal.
yeah. Somebody mentioned the most compelling witnesses. To me, the most compelling witnesses were Joe Woods and Ann Pinkerton. They said out there, those people are competent, they're experienced, and they demonstrated to you how they put the red tape over the urine vial and the blood vial, and there's no testimony that was disturbed. Again, you're talking about the box they were shipping it in. Those two most compelling witnesses demonstrated, and nobody has testified that those samples were tampered with or damaged in this case. It was said by someone that there's no pharmacology to show that this affected the outcome of the race in any way or affected the performance of the horse. That is not required by the Arkansas rules. It is not in there. It's either you have it in your system over a certain limit or you don't. You don't have to prove it had an effect on the outcome of the race. It's just not there. Talking about fundamental fairness, somebody mentioned fundamental fairness. Fundamental fairness is you choose the lab, you send the samples off to the lab tests them positive, and now you're trying to weasel out of it. That's not fundamental fairness. Fundamental fairness is you're stuck with the lab you chose and the diagnosis they made when they came up and said it was positive for lidocaine. That's fundamental fairness. And getting back one more time on this stuff about subcontracting or assignment or whatever, it defies logic that you can't subcontract or with a clause in there. It absolutely defies logic that you can't do that. It's against the terms. Well, it defies logic that you can't use the test lab, the University of California Davis. There's no logical explanation that they can advance to say that you can't use the University of California test lab when they chose it. Well, like I said, what you need to do is you consider whether there's substantial evidence to support the Stewart's rulings in this case, and you determine what is substantial evidence based on your experience, and you have the obligation to protect the public interest and the horseman's interest, the state's interest, and come up with a conclusion. can either vote to sustain the Stewart's ruling, to modify the Stewart's ruling, or to overturn the Stewart's ruling. And then we'll draft findings of fact and conclusions of law for you to sign at a later date.
Thank you, Mr. Freeland. At this point, councils, anything further? I don't think we have any record issues. I think we've done all our closing arguments and rebuttals. Commission, at this time, you're going to be done with me. My role is more or less over. I do have about a 2-sentence capper after you make a decision before we close the hearing. At this time, we're going to go off the record in a second to let the commission make their decision. As Mr. Freeland mentioned, a findings of fact and conclusions of law order will be drafted by one of the parties. I will let you all sort that out after the decision is made. Thanks to everybody, council, commission, y'all have made my job very easy. I think we've got a good, clean record. And while this was a lengthy hearing, it was not that hard. I've had pro se hearings that went much, much, much rockier. So thank you all very much for that. So with that, I will bow out and say at this time we're going to go off the record for the commission's recess for deliberations and a decision regarding the findings of fact and conclusions of law. Once they reach a decision, we will go back on the record and we will hang around and wait for that. Anything further, councils?
No, thank you.
You're certainly welcome.
Yes, sir.
All right, we're off the record.
Thank you, Mr. Faulkner, and I'd like to thank both sides for their professionalism. And it's been an interesting day and a half, day and 3 quarters. And I think, like I said before, there's not going to be a winner, loser in this one way or the other completely, because we're going to be criticized for whatever we do. But would y'all like to discuss it more, or the chair would entertain a motion? I think the motion would be to uphold the steward's decision, or override the steward's decision, or change the steward's decision.
Mr. Chairman, it's just this Commissioner Post, of course, I guess he's not doing that anymore. There's abundant evidence that the horse was exposed to lidocaine. I trust our land. I trust our people. There's also abundant evidence that it was at a level, a pharmacological level, below what would be performance enhancing. Uphold the stewards.
Uphold the stewards. Restore the horse to its position. And no days given to Mr. Baffert.
That's correct.
That's great. I have a motion and a second. All in favor, please say aye.
Aye.
Opposed? Ayes have it. It's over with. Thank you.
In that event, Mr. Chair, can we go back on the record for a formal vote now, just for record purposes?
Yep. I would like to say one other thing. I think doing this during the pandemic is our people did not get the credit that they deserve for having to go through this, not having to go, but going through this during the pandemic. And we've all had sad tales from the pandemic. But it made it much, much more difficult on several levels. And but let me say this, I'm proud to serve with this commission because we've always tried to do the right thing. Thank you.
We are back on the record. Commissioner, I know you've reached a decision in your deliberations. Would you just simply duplicate that now on the record for the court reporter?
I gotta say it twice.
Apologize if you would.
I'm gonna have to write this order, and so I don't know if I followed all of it. And I'm probably not the only one in the room that didn't follow all
I'm
of
the
it.
second one that didn't follow, okay? But the motion was and voted on that we reduce the fine on Mr. Baffert to $5,000 per horse, but
Okay.
restore the horse to its place, but also do away with the 15-day suspension.
Okay, but, you know,
When you restore them, that person money goes back to the,
my understanding is Mr. Babbitt wasn't fined in the first place, but what we're doing is fining
we
Mr.
now
Babbitt.
we're fine, is that what you're saying?
He's being fined $5,000 for Charlton, $5,000 for Gamine, but Charlton and Gamine will be exonerated and placed back as the first place finishers in each race, is that correct?
That's correct.
Okay. And then the suspension is lifted, there'll be no 15-day suspension.
That's correct, sir.
If I might be hyper-technical, I think the discussion was to uphold the ruling, uphold the steward's ruling, correct, was the first. I'm just trying to make the record
After
clear.
the after the 5,000.
Yeah, with those modifications.
With modifications, yes.
Modifications, correct.
I should make sure it's on the record and clear.
Is that a legal issue?
I'm just being ultra careful.
Everything is legal. I believe more in Shakespeare every day.
Thank you.
Let's do a formal vote on the record if we would.
Okay. All in favor, please say aye. Aye. Opposed? The ayes have it. Thank you.
Mr. Field, are you comfortable with writing that order now that you've heard it?
And again, thank you to both parties. It was a difficult deal, and there were problems on both sides. And it is not the perfect answer, but it's the best we as humans could do.
And just as a capper, council, please reduce this to writing and make or attempt service on the parties. I'm sure y'all will agree on the order eventually. If anyone appears, wants to make an appeal of this decision, it's appealable under the Arkansas Administrative Procedures Act, 25-15-212. And with that, I'll close the record. Thank you.
Mr. Chairman, I have one more item.
Yes, sir.
We've been asked to approve the dates for the 2022 live racing meet in Oaklawn. Those dates are January 28th through May the 7th. And I had a calendar that I can present that we can put in the records and ask that you approve these racing dates so that Oaklawn can advertise those racing dates.
Thank you. We're going to work on the racing days. Do I have a motion?
Second.
A motion and a second, Mr. Rice. All in favor, please say aye. Aye. Ayes have it. Thank you.
Okay. I will, this will be in the minutes, and I've got your, thank you.
Good to see you.